146.
1-4 repeat. 1-4. Okay. You don't want to do it?
No, sir, I have not counsel in this case. So he informed me on telephonic that just.
If you are not the counsel in the case, how do I adjourn on whose behalf? On the behalf of some ghost?
If he on telephonic instructed me. that
What
he is out
telephonic
of
instruction? I can't adjourn it in whose behalf.
session. I have also not brief available.
You don't have the brief, don't mention it. Ask him to appear through video conferencing. And tell me.
Supplementary list, top of the list item 41 and 42.
Yes, tell me, how is this
My lord, this is,
2-7 maintainable?
yes, my lord. My lord, before that, may I take your lordship to some annexures? Because this is an order passed by the Educational Tribunal. District Judge come Educational Tribunal.
Huh?
Educational Tribunal,
This order is passed by Educational Tribunal,
yes, my lord.
District Judge.
District Judge.
But if it's an injunction order,
Yes,
then obviously an appeal lies.
my lord, may I just indicate why this is without jurisdiction? May I take your lordship to page number 81, sir?
Page number?
81, annexure 5.
Yes.
This is the certificate issued by the National Commission for Minority Education Institutions and serial number 1, Monfort School, Post Bus 5, Chabua PO, Dibrugarh, is the one of the minority institutions as per this certificate. Now your lordship will kindly come to page 97, the notification for constitution of educational tribunal. May I just read, it's about small notification. In compliance of order dated 19/3/2015, passed by the Honorable High Court in WBC number so-and-so, WBC number so-and-so, and as per recommendation of Honorable High Court, the Governor of Assam is pleased to designate the Court of District Judge and additional district judges of each district to function as educational tribunal to adjudicate disputes relating to the teaching and non-teaching staff of the non-government educational institution as well as the disputes concerning disciplinary action and claim for provincialization in respect of teaching and non-teaching staff of ventured educational institutions within their respective territorial jurisdiction from the date of issue of this notification. So this notification is only concerned with the non-government educational institutions.
As well as those institutions wherein claim for provincialization.
Claim for provincialization and the disputes.
This is
regarding-
done under the 2017 Act.
This is
There's
the
the one act, no?
2006,
Huh?
2006,
No, no. No. The new one, the
17.
17.
But the definition of the non-government educational institution is given under the Assam Non-Government Education Institution Regulation and Management Act 2006. And may I just read out section 2, subsection Roman 15. It says, non-government educational institution means schools established and run by an individual or association of individuals or any non-government organization or society or trust, except the schools established and maintained by the minorities under clause 1 of Article 30 of the Constitution of India and imparting education at primary, middle, secondary and higher secondary level without receiving any grants in aid from state government, excluding the educational institution run or aided.
So you mean to say that non-government institution out there would not include the minority?
Minority institution.
That is your subject.
That is true.
Now, then,
Now, if your lordship kindly take up the order, implement order here.
what is this judgment passed by somebody?
Order is, my lord,
It's 98.
that High Court order, my lord.
Passed by some full bench.
That was for constitution of educational tribunal that I have annexed at page 198. Pursuant to this full bench decision, the district judges and additional district judges were constituted as educational tribunal in each and every district.
Then,
But before that, the petition, the respondent, private respondent had approached this honorable court with the similar,
so this is for education institution,
yes.
education tribunals. Then,
tribunal. Before, prior to that,
then what happened? What suit has been filed?
one suit has been filed.
Suit has been filed before
Before the district judge come educational.
where is the suit?
Why not play, page 24, it starts at 25.
Yes.
This is the suit. And the prayers, your lordship would find at page 55.
Order of termination is void, illegal, inoperative, and liable to be cancelled. Then,
Then, my lord, this ex parte order was passed, page 60.
huh?
Page 60.
Page 50.
60. The operative part is page 61, last paragraph onwards.
Okay, then,
This
now
is-
what are you challenging?
Now, I am challenging this order because this is without jurisdiction, passed without jurisdiction. The learned educational tribunal held that it is a non-government education institute.
No, that is another aspect.
Yes, ma'am.
Are you challenging that this order is without jurisdiction
Yes,
because the educational institution, educational tribunal does not have jurisdiction over the petitioner?
Yes.
Or is it your case that you are challenging this order because the educational tribunal does not have the power under Order 39, Rule 1 and 2?
no, ma'am. This is without jurisdiction, first one. Because the
Then you have to
education,
file a writ.
I filed a 227, your order.
No, you can't file a here, then you have to file a writ, because this is an order passed by an educational tribunal, which is being created. Now, if you are therefore challenging that this authority does not, the court does not have the jurisdiction, to file, you have to file a petition under Order 7 Rule 11 there.
That we have.
So therefore, that is another aspect of the matter which I can take it up. But therefore, I was asking that if whether the educational tribunal have the power to exercise the powers under Order 39, Rule 1 and 2. If that is the question, is another aspect of the matter.
In the mis case, they have prayed for under order 39, 1 and 2, but we are saying that only that the educational tribunal does not have the jurisdiction to pass this
So
order.
if the tribunal does not have the jurisdiction to pass the order, then it is a different aspect of the matter where the court does not have, for which you may have to challenge it somehow. But how this court, if it is an order under Order 39, Rule 1 and 2, how will this court take it as a proceedings under what do you call?
227.
About 227, more particularly when an appeal lies. It's a different thing. If you may say that the educational tribunal does not have the power under Order 39, 1 and 2. And if it is so, then an appeal shall lie where? From an educational tribunal to where?
Court, my lord.
High Court under what?
26.
Educational tribunal is a creature of a statute. So against that, an appeal will lie against what? Because if he doesn't have the jurisdiction.
But I am not on that. I am only on that, this educational tribunal exceeded its jurisdiction and doesn't
No,
have.
it is not a question of exceeded jurisdiction. It has, doesn't have a
have
jurisdiction.
jurisdiction.
If it is a case of does not have a jurisdiction, then it is a case of 226.
Well, under 227 also, your lordship can.
How? I don't have the jurisdiction for 226.
227, my lord.
227, how do I do it? Because its tribunal comes within the ambit of this court.
My lord, may I place one or two judgments in this? regard?
Please do. What is the name?
My lord, Kishore Kumar Khaitan and another.
What does it say?
My lord, it says that order jurisdiction under 227 is to be invoked only to correct the errors of jurisdiction.
So are you therefore not challenging the entire proceedings before this court?
Only in the miscase.
Why? So you have to challenge the entire proceedings. I'm asking you, you have to challenge the entire proceedings before this court under 227.
Three parts.
Are you saying that your basic case is you don't come within the ambit of a non-governmental institution. And as such, by virtue of the power which is being conferred by the notification, which you have referred to at page 81, if I'm not wrong,
Even the tribunal also,
the tribunal does not have the jurisdiction. So therefore, you are exercising or challenging the very jurisdiction for taking it up. So that means the entire proceeding has to go. So therefore, you have to challenge the entire proceedings. Initiation from filing about the proceedings onwards. But if you are only challenging the interim order, then in the case thereof, the proceeding still continues out there. But the moment I hold it, that it does not, the proceedings gets finished there.
right? So
And this, then if it is an exercise of jurisdiction under Order 39, Rule 1 and 2, then therefore the course out here would be the appellate court. So therefore, you have to therefore say that this educational tribunal has no business as regards Order 39, 1 and 2. But that is not your case. Then how do I exercise jurisdiction?
my lord, 227, my lord, as I can understand from this Kishore Kumar Khaitan.
Kishore Kumar Khaitan is, there are more subsequent more judgments
Yes, madam.
wherein Supreme Court categorically says that you cannot touch when there is an appellate provision.
Right, case also the,
After Surya Dev Rai, there are many other judgments also. Wherein it says that I cannot touch.
but if the jurisdiction, the court doesn't have jurisdiction to entertain an application.
So
of
therefore, the challenge has to be on the question of jurisdiction. And the entire proceedings has to. But that is not your challenge out here.
the
You are
hearing-
challenging only a miscellaneous order.
Yes.
Then if you are challenging only, your challenge is only to the miscellaneous order, which I am again repeating, then it has to be an appeal. But if you are challenging the entire proceedings before the tribunal, before the tribunal saying that the tribunal has no jurisdiction out here, and as such, this court being a supervisory jurisdiction having over the jurisdiction over all the courts, including all tribunals under it, therefore this court should exercise its jurisdiction. Because the very initiation of the proceedings is wrong.
This is the first order, this is the first initial order passed in the case. And as such.
So the question should have been, otherwise the question is actually it should have been a suit filed in the regular course of business.
Yes.
It couldn't have been before the tribunal. Isn't it?
Before the
Chalo.
civil.
We maintain this order and ask the district judge to put the matter before the civil judge.
My lord.
Because once it is comes before the civil judge.
Definitely, I can.
Okay, one. Now let us take the case of a Bengal Agra Assam Act. The jurisdiction lies before whom?
For the civil judge.
Before the civil judge? No. The jurisdiction lies before the, although section 15 says that it has to be filed before the court having the list of the jurisdiction initially.
Yes.
But otherwise, the district court have the jurisdiction, district judge. Let us not take it as an educational tribunal. Let us take
If
it,
it is not acting as an educational tribunal,
but then the jurisdiction is there.
but regarding the pecuniary aspect,
Why pecuniary? The civil. Therefore, when you file a suit, you may file it, you put the name of whatever may be. Doesn't it goes to the district judge for allocation? Because the district judge has
And
the
district judge is
oversight
district judge.
power.
district judge,
And taking into account section 15, the district judge therefore allocates, because section 15 is procedural.
proceed.
The power is there under the Bengal. So therefore, the power which is being there is given to the district judge.
Correct.
So therefore, the district judge, you can't say the district judge doesn't have the jurisdiction. It may not be an
Education.
as an educational suit. It may be a suit, whatever these people may put it as a district judge come educational tribunal, it should have been a normal suit. It should have been wrongly, it has been put out there. So the only thing is that the court should transfer it to the appropriate court.
And quote that.
But does the district judge has no jurisdiction to pass this injunction?
Because in my humble submission, district judge doesn't have
Why?
in this case. Because the district judge is acting as an educational tribunal.
No, it is, he has said it to be the educational tribunal.
Yes.
Come, district judge come educational tribunal.
It's fine.
It doesn't
In
say
the-
district judge, educational tribunal,
The order itself, page 62.
whatever may be. So therefore, there is no challenge to that order. But the power is there with the district judge to pass an order. See, the Bengal Agra Act, the power is given to the district judge to pass the order. So then,
Power to pass an order of in this fashion that whether it has jurisdiction and not. After discussing this, whether the district judge has the power to pass an order of injunction in this matter. That is the only.
now just for example, tomorrow, let's give you an example. You file a suit before the Munsif. The Munsif is not there. Who is going to pass an order? You need an urgent relief. Where do you get the order?
Other.
No, the Munsif, there's only one Munsif. There's one civil judge. Okay. Who will pass that order? Means a person will have no right to get an injunction.
No, man.
Who gets the power? Then you have to file an application before the district judge. The district judge can then take the matter out and pass an order by himself or allocate it to some other court.
That is.
Isn't that the law?
Yes.
So if
But
that be
here-
so,
here
therefore the district judge has the power.
But here the district judge himself passes the order.
So that was in that circumstance also the district judge can pass an order. See the Bengal Agra Act 1887. That is the power which is being given. Like Central Act. So Sharma, isn't that what happens before the trial court? Just for example, tomorrow the Munsif is not there. There's only one court.
Section
The-
24,
Ah,
district judge can pass the order.
the district judge can pass the order
And send it back to again to. the-
and send it again back to the Munsif.
the
This is how it regulates. And the power is given by the Act of 1887. Mind you, it is not given under the code. The code only regulates the procedure. And therefore, for regulating, it says that you file the suit in the lowest jurisdiction where it is there. So you file it there, But the court can very well take it. And wrong filing in that court, however, the district judge has the jurisdiction. Not maybe as an educational tribunal, but this. Kindly see this. Section 18, save as otherwise provided by an enactment for the time being in force, the jurisdiction of the district judge or the sovereign extends subject to the provisions of section 15 to all original suits for the time being cognizable by the civil courts. That is section 18. Now, extent of the jurisdiction of the munsif, save as otherwise provided the provisions of so and so, which value does not exceed 1,000 rupees and so and so. So this has been amended so and so. Proceedings taken cognizance of or transferred to a subordinate court as the case may be under the last one shall be disposed of by him subject to the rules applicable like the proceedings when disposed of by the district judge. So let us take care of your jurisdiction issue here only and then direct the year to take it up, place it before that. It will be a civil suit. Jurisdiction will be 42,000. What do you have to say? What yes?
District judge has the power, your lordship.
And what is the other matter for?
Similar way. In the,
There are two suits.
No, one suit, two miscases.
What is the other miscase?
Other miscase is for status quo.
Status quo for?
Status quo, only status quo, madam. Order is page 63. They were proceeding with the.
But I give you the liberty to file an appeal against these orders, taking into account the jurisdiction is there, but you may prefer an appeal. Heard Mr. A. Third or learned counsel appearing on behalf of the petitioner. Miss, what's your name? Pia?
He does,
P. Das,
for secondary,
who appears on behalf of the
secondary education.
respondent, respondent number 1.
Two, madam.
In both the proceedings, the petitioners herein have assailed petitioners herein have assailed the orders passed under Order 39, Rule 1 and 2, in proceedings under Order 39, Rule 1 and 2. whereby certain ex parte prohibitory as well as mandatory directions have been issued by the learned district judge, Dibrugarh. First, taking into account that the issue involved in both the proceedings are one and the same, this court takes up both the proceedings for disposal by this common judgment and order. First, Mr. Idhor, the learned counsel, appearing on behalf of the petitioner, submitted that the petitioner number one is a minority. Where is that document?
81,
Huh?
81, page 81.
Is a minority educational institution and this aspect of the matter would be apparent from the certificate issued by the National Commission for Minority Educational Institution dated 21/3/2012. He submitted that being a minority educational institution, the petitioner school would not come within the ambit of a non-governmental educational institution, as would appear from the very definition of the non-governmental educational institution contained in section
Section 2, Roman 15,
2 Roman 15 of
some non-government educational institutions, Regulation and Management Act 2006.
so and so. For short, the Act of 2006. The learned counsel therefore submitted that that the petitioner being not an non-government educational institution, the educational tribunals which have been constituted under
By notification, page 97.
by no constituted under what provision?
This is pursuant to the full bench decision,
No, full bench cannot constitute. There is somewhere something.
page 97, madam.
No. Somewhere something is there. See, the power over a court cannot be given by a full bench.
Page 97 is the notification.
Give me that act.
Minority.
Assam. 8576. This creation is under 28A. Somewhere the power has to be there. Constituted pursuant to an interpretation of section 27 of the Act of 2006, read with Rule 21D of the Assam non-government educational institutions bracket regulation and management rules 2007, given by the full bench of this court in the case of Abdul Ghafoor Mondal versus State of Assam. And the subsequent notification issued on the basis thereof, dated 3/12/2015, whereby the court of the district judge and additional district judge of each district have been empowered to function as educational tribunals, would have no jurisdiction. The learned counsel for the petitioners therefore submitted that the learned district judge, Dibrugarh, could not have exercised jurisdiction over the petitioner school as an educational institution and passed the impugned orders assailed in the instant proceedings, assailed in both the proceedings, in exercise of powers under Order 39, Rule 1 and 2, read with Section 151, for which interference was sought for to the said proceedings, to the said orders by way of the present proceedings present applications filed by invoking the supervisory jurisdiction of this court under Article 227 of the Constitution. First, this court, upon hearing the learned counsel appearing on behalf of the petitioner, put a specific query upon the learned counsel as to whether the proceedings, instant proceedings, only relate to the challenge to the impugned orders, whereby the learned district judge has exercised powers as powers for grant of ex parte, mandatory as well as the prohibitory injunctions. The learned counsel submits that by way of the instant proceedings, the order dated 8/1/2024 passed in Ms. case number 4/2024, as well as the order dated
1/2/2024.
wait. As well as the order dated 1/2/2000, in Ms. case number 11/2024 have been put to challenge. In the backdrop of the above, let this court now take note of as to whether this court should exercise its supervisory jurisdiction to interfere with the orders dated 1/2/2024 passed in Ms. case number 11/2024 and 8/2/2024. Is that order passed in Ms. case number 4/2024. First, it is very pertinent to take note of that these orders have been passed in exercise of powers under Order 39, Rule 1 and 2. And under such circumstances, an appeal lies under Order 43, Rule 1R, read with Section 104 of the Code. At least this court finds it relevant now to take note of a judgment of the Supreme Court in the case of Vihat Mumbai, so and so, wherein the Supreme Court has observed that when there are provisions provided in the code for filing appeals, the jurisdiction under Article 227 of the Constitution should be taken as an absolute bar. Paragraph so and so of the said judgment is reproduced here in under. Be that as it may, this court finds it very pertinent now to take note of as to whether the jurisdiction whether the learned district judge, Dibrugarh, had the jurisdiction to pass the impugned orders, taking into account the submission made by the learned counsel appearing on behalf of the petitioners. First, the certificate so issued by the National Commission for Minority Education and Institution dated 21/3/2012 makes it very clear that the petitioner school comes within the ambit of a minority institution and have been declared so in terms with Section 2G of the National Commission for Minority Education and Institutions Act 2004. First, this court further finds it relevant to take note of the definition of non-governmental educational institution as contained in Section 215, bracket X5D, of the Act of 2006, which defines the said term. First, Section 215 of the Act of 2006 being relevant is reproduced herein under. First, from the perusal of the said definition itself, it would be clear that the schools established and maintained by minorities under Clause 1 of Article 30 of the Constitution is outside the scope of non-governmental educational institution. First, is outside the scope of the definition of non-governmental educational institution. If such schools are imparting education at primary, middle, secondary and higher secondary level without receiving any grant in aid from the state government, excluding the educational institutions run or aided by the central government or the state government. First, are you receiving that? Mister, are you receiving grant in aid?
No.
How do I know?
Well, we have made a statement.
No. Categorical statement is a question of jurisdiction.
But we are not receiving any grants.
Then merely saying it to be minority would not come out.
This is the certificate we have annexed.
It doesn't say that you have not received.
The Minority Commission for Education Institution Act 2004 says it.
What does it say?
Government will say whether this is whether they have to be giving us.
Huh?
Government will say. Government will say.
No. That is a question which has to be decided there. Isn't it? Huh? Because it not only mentions about minority, but also says that if you have not received,
Yes.
then it will go outside. And then it would be a case of what? It can't even come within the ambit of Order 7, Rule 11. It's a question of fact. From the above definition, therefore, it is clear that merely being a minority institution, educational institution, would not take the institution, take the petitioner school outside the purview of the non-governmental educational institution, unless the petitioner school have been imparting education at primary, middle, secondary, and higher secondary level without receiving any grant in aid from the state government, excluding the educational institution run or aided by the central government or the state government. First, this aspect would require a finding of fact which the learned tribunal, which the learned district judge would have to exercise if such appropriate applications are filed before the learned district judge. Considering the above, it cannot therefore be said that the petitioner company, petitioner school, would be a non-governmental educational institution and outside the purview of the Act of 2006 at this stage. First, under such circumstances, it is therefore the opinion of the court that the question of exercising jurisdiction under Article 2 to 7 of the Constitution against orders passed under Order 39, Rule 1 and 2 would not arise in view of the clear observations made by the Supreme Court in the above quoted judgment, namely in the judgment of the year of the above quoted judgment rendered in the case of so-and-so. Accordingly, this court does not find merit in both the petition, does not find merit on the submission pertaining to the effect that the learned district judge did not have educational institution educational tribunal did not have the jurisdiction. Accordingly, the instant proceedings, both the petition stands dismissed. Be that as it may, this court cannot also be unmindful of the fact that the challenge which have been made, be that as it may, taking into account that the instant petitions have been dismissed on the ground of non-maintainability, liberty is given to the petitioners to assail the impugned orders dated so-and-so, passed in miscase number so-and-so, dated so-and-so, passed in miscase number so-and-so, if so advised. And the period from 2024 till date be excluded while computing the period of limitation. First, the interim orders passed earlier stands with.
I'm deeply obliged.
You are also that school also, no? The director of that school. Can you appear in this case? No. You are appearing for whom?
Education department.
She is there. Not for the respondent, sole respondent, no performer. Respondent
There
has
are
not.
two respondents, private respondent and the education.
No, she is appearing for that. I thought that she was actually appearing for the respondent. No, for the performer. None appears for the respondent on number one on call. You filed that appeal.
For motion item 1.
But it would have been interesting if the other point could have gone.
Then that is why perhaps order 7 rule 11 is not.
That is why it has not been filed. But you have a good case for challenging the injunction.
In a pay.
It has been passed in a very bad.
Obliged, ma'am.
Yes, what is this? Transfer petition.
Sir, I am extremely sorry, Joseph, some more time may be granted to
For
file my,
what?
to file my additional affidavit as directed by this honorable court. Lordship, while filing this petition, I have not annexed the petitions filed by the petitioner wife before the court of Nolbury Lordship.
Ah.
So this court has directed me to file an additional affidavit to bring on record the petitions filed by the wife before the court of family court Nolbury as well as before the court of Chief Judicial Magistrate Nolbury Lordship. I have received the copy, but Lordship,
Have you filed your written statement?
no, Lordship, I have not received the notice. On last occasion, I have just appeared and asked to, they have served on notice by way of paper publication, Lordship. So, Lordship, I have appeared and I have asked to provide me the copy of the petition, but on that day, Lordship, the petition, copy of the petition was not served upon me. And next day is fixed on 5th of August, Lordship. So 1 week time, you granted, Lordship, I will file my.
After vacation. You have no, I have given you, if you can't get it for a month, now how do I give you? This type of stuff, the Mr. SN, so and so, the learned counsel appearing on behalf of the petitioner seeks for a further accommodation. First of list the matter for filing the additional affidavit. First of list the matter again on 16th of July 2025.
Item 2,
May please. Today, we have filed a affidavit, additional affidavit. Yeah, my lord, but I have an extra copy with me, my lord, regarding the loan and his treatment and all.
Oh, this one,
Yes, my lord, the railway.
you have not filed.
No, I have filed, my lord.
Where is it?
The morning I have filed. I had
Ah,
extra copy.
why did you wait for the last date?
Oh.
You knew it, you should have filed it.
No, today morning I filed it, my lord. He has come in Friday, so the affidavit, Saturday was closed.
Okay. Mr. K. Bachcharji, the learned counsel, appearing on behalf of the petitioner, seeks for some more accommodation. And it submits that the affidavit has been, additional affidavit has been filed pursuant to the directions passed by this court on 30/5/2025. List this matter again on July, June, 23rd.
My lord, he-
23rd of June. 23rd of June. So the registry shall bring on record the edition.
3,
Okay, motion नहीं. Motion हमलोग देखिए. Yes, Mr.
My lord. this is
Sharma, what
regard-
are you challenging?
This is regarding, my lord has passed some direction earlier in this case. That the disposal of this appeal by the additional district judge and the injunction appeal. And because earlier the district judge has disposed of the appeal basically on two grounds, that court has no territorial jurisdiction, the trial court, and one is that the suit was not maintainable.
What are you challenging here?
And here, my lord, again, the matter came up before the additional district judge, and the additional district judge has said that it has no pecuniary jurisdiction, my lord, the relevant order, my lord, at page 146.
No, understood. What is the, this appeal?
My lord, here, what happened in this case, in
On
injunction
the
was,
pecuniary jurisdiction of this court to hear the instant appeal. Why is he writing such a long judgment on a small? What is the value of the suit?
Value of the suit,
Value of
20
the
lakhs
suit
we have
was
clearly
20
determined.
lakhs.
Value of the suit, 20 lakhs we have clearly determined.
20 lakhs.
Yes, my lord, only injunction we have separately, for the purpose of court fee, 100 rupees you have indicated. That's why the views of the learned appellate court below was that because it is the separately that we have mentioned 100 rupees, therefore the value of the suit would be 20 lakhs 100. It exceeded the limit of notification 2020. Lordship, it is a settled position of law that suit can be, the item can be separated, my lord, for the purpose of court fee, but ultimately the jurisdiction is to come once that, my lord, the party which has been indicated in the top of the body, that what is the suit value. On the top of the body, we have indicated 20 lakhs. Therefore, my lord, only for the purpose of, there are so many items, my lord, maybe there, for the purpose of paying court fee in terms of the section 7 of, my lord, the court fee act. But it cannot be accumulated that it separately, that finally the figure will come up. No, that is not the principle of law, my lord. This is decided case, my lord, numbers of cases are there in that line. But prior to lordship, may I point out only one thing, page 48, my lord, page, my lord, 20, my lord, for a moment.
Let us see the plain.
The plaint, my lord, yes.
20 lakhs, it is valued at rupees 20 lakhs,
What is happening?
one, and ad valorem court fee of rupees, the fixed court fee of rupees is also paid.
Lordship, plaint contained in page
25.
25, my lord. For the purpose of jurisdiction, the suit is value of rupees 20 lakhs. And the emphasis given by the learned court below in regard to paragraph 28. That is in page 48.
Ah, you are right, paragraph 28.
Yes.
For the purpose of declaration, the suit is valued at rupees 20 lakhs.
Yes.
And for the purpose of permanent injunction, the suit is valued at 100.
100.
Then,
Therefore,
isn't it 20 lakhs 100?
my lord, reason is that, my lord, the decided cases, I have gone through, my lord, 2 or 3 cases. It says that, my lord, for the purpose of, my lord, paying court fee, amount can be separated in respect of the item which is indicated in court fee act section 7, my lord, in the item. But the jurisdictional value will not be in that way, that suppose the separate court fee has been indicated for the purpose of, my lord, the subject matter. It cannot be accumulated finally, the court, ultimately jurisdictional purpose would be served. What is the value that has been indicated the parties concerned, my lord? That, my lord, judgment is 1998 3 SCC 428. Right now, my lord, I could not prepare all the things. Lordship, prior to that, lordship, may I point out one thing about the maintainability of this petition itself, my lord. Lordship, that page 20, lordship is just moment for page 20, my lord, of their petition, my lord. No doubt this is one of the core issue, but page 20, my lord, they have made a dual challenge here, my lord. Injunction order, my lord, in page 20, they have challenged 2 orders here, my lord. That is 121/2023 passed in the trial court in respect of injunction. And, my lord, the another order 29/5/2025. My so far 21/2020 is concerned, my lord, 23. It comes on anyway, people order 41 rule 1R, my lord. It cannot be clubbed together here, my lord. The petition itself is, my lord, suffering from informative, my lord. It is not maintainable, my lord. Either they have to challenge this separately, otherwise it is not possible. But so far the next 29/5/2025 is concerned, my lord. That will come in a way of revision, my lord. Here, my lord, the both things have been clubbed together, my lord. Maintainability is a question, my lord.
Now, what is this 29?
29, my injunction, my lord. Injunction passed, appeal they filed. They, my lord, against which we have preferred revision before this honorable court. This revision court remanded back while dealing with the revision order by the appellate forum, my lord. This 29/5/2025 cropped up, my lord. This order otherwise not possible because until the issue to be decided in respect of the order dated 29/5/2025, nothing survived, my lord.
Wait, I pass some order.
Yes, my lord. That contained in page, my lord, 137, my lord. Start from page 136, my lord. The directive part. Page 144, my lord.
143 will be relevant. There are 11.
Just 14, my lord.
So I have interfered with that.
My lord.
Then
Then, my lord, this matter was taken care of.
Direct revision was director, you have to appear before the learned first appellate court on demand. The learned first shall hear for hearing of the said appeal as per the business.
court has interfered the order, basically in para 11 is important, no? At page 143. Why this court has to interfere the order?
So here, this court had decided some things and said that those points can't be hesitated,
Yes.
but remanded it back to the learned first appellate court, as the first appellate court touched only on the question of maintainability of the appeal.
Yes.
And also took into consideration the prima facie case without taking into account the other two elements. Okay, then
Then, my lord, the appellate court then decided the appeal basically on the pecuniary
Page
jurisdiction.
149, madam.
And that pecuniary jurisdiction point, he has raised so moto. We, both the parties, we have considered that this court has jurisdiction. And then he dismissed the appeal.
on this point,
On this point, he has dismissed the appeal
on his own,
on his own. We both have argued that this court has pecuniary jurisdiction and the matter of the consequential relief, value of consequential relief should not be clubbed with the suit valuation.
both of you argue.
Yes,
Yes, on this point, that 2-3 argument was taken place,
Huh?
madam. On this point, 2-3 arguments were taken place, but we failed to convince the court below that.
and court, instead of returning back the appeal, court has dismissed the appeal. Page 158. Right.
Okay, now let's see the judgment which you are referring to, that it should
Yes,
not
yes,
have been
yes.
taken.
Actually, morning, Lordship, can I just fix after 1 week, my lord? Because, Lordship, that 2 or 3 judgment I have gone through, 1988.
Go through. I need only one.
Oh, my lord, this judgment, yes, this judgment.
Only one judgment,
Yes,
let
yes.
me go through it. Then what I'll do.
Yes.
If I feel
Yes, ma'am.
that yes, the appeal should have been filed here
Yeah, madam.
and convert this into an appeal.
Yes.
And if no, I'll set aside this order immediately.
Yes, madam. That is the ultimate relief, madam.
What is this? You are getting me an order of this. Where's the Supreme Court judgment?
It is not Supreme Court judgment, madam. From Madhya Pradesh.
No.
If the Lordship please to see one judgment 1990, 88, CSCC 423.
19?
1988. CSCC 423, my lord. Where, my lord, it is said that can be assessed and charged separately for courtly purposes, but not for jurisdictional purposes.
1988,
3 SCC 423, my lord.
PSC 4,
3 SCC 423, page number 423.
42.
Yes, ma'am.
What is the name? 88,
Yes, 1988, 3 SCC 423, commercial
4
aviation.
to 3.
Yes. Commercial Aviation and Travel Company Limited versus Bimla Pannalal.
But I think the learned trial first appellate court is right.
My lord, the lordship-
Because a question arose, similar question arose in a proceeding pertaining to the consumer protection. An appeal lies, the jurisdiction of the consumer protection is less
Well,
compared to the district is a particular amount.
well,
and how the first appellate courts here. Now, what has happened? He not only asks for that particular relief, but also asks that along with that, I have to get this alternatively December. And it was held because of that issue. Now,
But
let us
only
see.
one line is very important, 40 Act, section 7.
Referring to which one?
42, para 10.
It really means that in a suit falling under 748, the amount stated by the plaintiff as the value of his claim for partition has already to be accepted in computing the court fees in respect of the relief. In circumstance of this case, it is unnecessary to consider whether under the provisions that the plaintiff has given an estimate.
Section 7 of the Order 7, Rule 1, I also speaks the statement of the value of the subject matter of the suit for the purpose of jurisdiction and the court fee so far as the case admits.
No, this is a case coming under 74C.
Yes,
My lord, kindly see from on section 7, 4C, there are two facet, my lord. Section 40 Act, It, my lord, the last line is little bit, my lord, they require clarification from your lordship, my lord. Section 4, section 7, Roman 4, last line, according to the amount at which the relief sought is valued in the plaint or memorandum of appeal, my lord. The line is in like that way, my lord. Therefore, my lord, we have mentioned about the value of the declaration, which is the main relief, is 20 lakhs.
No, no, no. I think both has to be.
Yes, ma'am. Now, lordship kindly see that if suppose both to be clubbed here, for a moment, lordship kindly see that.
No, that is one. But the second aspect is, could the court have gone into that issue?
Lordship, there are two cases. Lordship, one is main relief, second is consequential relief. For the pub, because we have, in terms of the court fee, we have to pay separate court. Suppose there are other items are there, my lord. Under section 7, then each item according to that, the whatever.
Mr. Samaria, when it comes under 7(4)(c),
Yes,
you do not do it separately. You go on a, yeah, category C. A court fee account. It doesn't say that. 7(4)(c) categorically says on the ad valorem,
yes, ma'am.
isn't it? Yes. Court fee. It says about ad valorem. It is not in a. It does not say. He may have wrongly done it.
Yes,
He has, in many cases, you
Yes,
see
yes.
what they do when you are asking for declaration with consequential relief. This is 7(4)(c).
Yes, ma'am.
So then in that case, then in some planes you find
Yes.
for declaration, they ask for the 22 rupees, put 22 rupees.
Go on.
And then for consequential relief, doing it with 100 and give 11 rupees, thereby 33 rupees.
33 rupees.
Actually, if it is 7(4)(c), you have to give on the ad valorem, if
Yes,
I'm
sir.
not wrong. In suits, finally, see, the amount of fees payable under this act in suits next hereinafter mentioned. In suits, for declaration, declaratory decree and consequential relief,
Correct.
in all suits, the plaintiff shall state the amount at which he values the relief sought for.
Yes,
And kindly come to here in suits so and so.
declaratory decree and consequential relief, the middle part.
He has to, demand, for instance, of demand in all suits, plaintiff here shall state the amount at which he values the reliefs. Here in paragraph number 28 of the
Right.
plain,
Yes, ma'am.
he has valued it as its
20 lakhs, ma'am.
20 lakhs plus for injunction.
And the injunction had separate, no, it's a
No.
aspect, ma'am.
If it is so, then it will come to the High Court.
Lordship decide we have nothing to say, but Lordship can you see that one line is very important. 7(4), last line, according to the amount at which the relief sought is valued in the plaint or memorandum of appeal. My main relief is my lord declaratory, my lord.
Without consequential, then 34 is head.
Consequential relief is my lord, my lord, that is the key relief is my lord declaration, my lord. The once declaration will come up, my lord, then automatically my it is subsequent, my lord, that is the supplementary part of that my lord relief, my lord. That is injunction or suppose any other thing, settlement of books of account or like that, my lord, so many items are there, my lord. But question is that, my lord, if I clearly mentioned the suit value will be 20 lakhs on the body of that suit. And downside also that relief which is otherwise.
No, you don't mention it in that manner. You have to mention the valuation of the suit as a whole with consequential relief.
Yes.
Kindly see, the amount of fees payable under this act in suits next hereinafter referred, in suits for declaratory decree and consequential to obtain a declaratory or order where consequently is paid. In all such suits, the plaintiff shall state the amount at which he values the relief sought.
Yes, ma'am.
It is not only the declaration,
Yes, ma'am.
the
Injunction-
consequential also will be there.
Yes, ma'am.
So wouldn't it be 20 lakhs and
My
100?
lord, little bit, my lord, thing is that the true judgment which I have gone through, my lord, in a hurry, my lord, that it says that court fee can be paid separately, but it will not attract, it will not jurisdictional purpose, my lord. This jurisdictional purpose is the ultimate figure that I have mentioned.
But you categorically mention in your claim to that
Exactly, my
effect.
lord, the items are on the basis of the
But in the caption,
requirement
my
of the
lord,
law.
But here you categorically say that for the purpose of declaration, the suit is valued at rupees
20
20
lakhs, my
lakhs.
lord. That has to be taken into consideration.
No, not only for declaration. You should have said for the
purpose of
declaration,
jurisdiction.
for the suit, you are valuing it at so and so.
My
The
lord.
question of doing it, this, what you have done is, I don't know what you have done,
My lord,
but this is the fundamental
normal practice.
mistake.
Yes.
You have to value the suit taking into account all release.
But my lord, in the
Consolidate-
caption, my lord, may kindly look at page 25. Caption, it is correct. At page 25. For the purpose of jurisdiction, the suit is valued rupees 20 lakh. That is correct.
It should have been, in that paragraph, it should have only put 20 lakhs.
Yes, yes, that should be written.
But what you did, you see, in the suits, plaintiff shall say the amount at which he values the relief sought.
Yes, my lord.
That wrong is.
So you are seeking two reliefs.
My lord, dual relief is, my lord, kindly see if there is an independent relief, my lord, yes, there is a situation that it's a second position that separately it has to be
In
paid.
fact, you should not, but you have done it by yourself.
No doubt, my lord.
But how, why are you against this?
No, I am not again, we consider that, that all this, because it's a legal matter, since lordship is now reopening the fact. What
No,
has-
I am not on that. My question is, when the appeal has been done,
Yes, my lord,
hearing was done, order passed,
yes, my lord,
and the matter having now again gone back
yes, my lord.
with a remand, should the court now, without deciding on the question of any other thing,
My lord.
anybody raise the question of maintainability
My lord,
there?
that answer, lordship, kindly see that the order itself reflect that we have raised this issue particularly by both sides, that there is a limited direction given to this honorable forum to deal with the subject matter. But if suppose across the limits and making something, then it's required a matter of suppose further consideration in different way. But the views which has been adopted by the learned appellate from below is in this way, my lord, about this point. Kindly see for a moment.
Where is your appeal memo?
My lord, appeal memo content.
Memo is not in this, not here. At my lord, the same language would have been there, like caption, then the jurisdiction value will go, my lord. And it is, and order 7 rule, rule 1 also speaks the statement of the value of the subject matter of the suit for the purpose of jurisdiction. So that should be there for the purpose of jurisdiction, suit is valued to the count. That will be suffice now.
You have put it at paragraph 28.
Yes, he has put it differently in paragraph.
Ah. Problem arises there.
And
Lordship,
secondly, my
paragraph
lord,
17, the answer is given by the learned appellate form, page 58, lordship, paragraph 17. So far, it is submission that since my predecessor have already heard the argument and passed the judgment in the instant appeal, and moreover, the Honorable High Court have set aside the said judgment and remanded for fresh decision of this court is concerned, I am of the view that neither my predecessor nor the Honorable Guwahati High Court has decided on the issue of peculiar jurisdiction of this court to hear this instance. Hence, this said argument has no force. No, ultimately, my lord, it's
Now,
a
what is this paragraph 19?
19 about, my lord, 7.4c.
Oh, so what, that is why it is not there. Where is your original plain?
Original?
Plain.
Yes, my lord, plain content in my lord.
No, not this. This is blank.
Yes, my original plain is in my lord part of it.
How much you have put here?
But 20 lakhs and my lord 100 rupees.
Now, how much court fee you have paid?
Court fee we have deficit payment. There is no doubt. Now 22 rupees we have paid.
Ah, that is why.
We'll pay, but there
I
is no
tell you, na, this is what it is.
Yes, sir.
So what he has done is, although he has valued it, now he has separately does
Yes,
it,
yes,
which is not the way. He has to pay on ad valorem.
yes, yes.
he has to pay on 20 lakhs plus
100 rupees.
100 rupees.
That is maximum court fee.
Yes.
Rightly said.
No, so far court fee is concerned, my lord, that is the issue because at no point it was raised earlier, first time it has been supposed pointed out. Definitely will fill up the gaps, my lord. There is no problem to that. Question that, my lord, so far these two items are concerned, my lord. First is declarative, second is injunction, my lord. If they suppose two reliefs are separate from each other, my lord, absolutely that will come that court fee has to be paid accordingly. But consequential relief can be amounted to the relief of, my lord, main relief, my lord.
Who has asked you to value the consequential relief?
But we have put the figure rightly, wrongly, but.
Now, how do I see that he is wrong? Taking into account the
The
statement
face
made in the
value, my lord,
claim.
the face of the claim clearly says that the suit value is 20 lakhs, my lord. That we have clearly indicated, my lord, and it is, my lord, ultimately kindly see that if power exercise under 21(2), my lord, CPC, my lord, testing the pecuniary jurisdiction, my lord. Then the first instance it has to be tested, my lord, at appellate court
No,
is barred.
tell me where it is that this statement in the plain
Yes, my lord.
you require in the matter of,
Yes.
where is it?
My plain, my lord, it's true, my lord, that in the.
No, tell me
Yes.
where in the plaint you have to mention in the matter of.
In the matter of, my lord, the
If
body
you,
itself.
because this is the in the matter of which we are concerned,
Absolutely,
but
my
in
lord.
the contents of your plaint is
No,
different.
Quite right, my lord, my lord.
Then
On page 25 in the plaint, we have clearly for the purpose of jurisdiction, the suit.
you
is
had filed
concerned.
the appeal, Mr. Sharma.
Yes, sir. And kindly see, my
And my
lord,
lord, that appeal was dismissed on the ground of pecuniary jurisdiction.
No, it was done, actually should have been returned.
My lord.
Should
That's
have
why
been
I
returned
present-
and given to you so
Yes,
that you
yes.
can file it here.
Yes, yes. Then I could have filed it here.
Yeah.
again.
So that
But
is what should
that-
have been done.
But by that way, he has exercised the jurisdiction by
no,
dismissing it.
lordship decide the issue, my lord. Suppose it will come within the jurisdiction of this honorable court, my lord, that will be converted in 41R, my lord. Otherwise, my lord, that will be remanded back, my lord. We'll consider there, my lord, our submission.
Chalo. We issue notice. Stay the injunction order.
My lord, injunction order, my lord, I have an objection, my lord, this.
You raise objection,
My
go to
lord,
Supreme
lordship
Court.
kindly see,
No
lordship kindly
question of
see.
objection. My lord,
My
that
lord,
was
injunction
detailed
order,
only.
my lord, kindly see, lordship, for a moment. Until unless the issue, my lord, first is required to be decided about, my lord, that pecuniary jurisdiction's part. Afterward, my lord, kindly see that it is just revision which they have filed, lordship kindly see that dual period cannot made, my lord. Page 20. Page 20 clearly says they have challenged the original order of injunction 21/2023, which is the effect of order 41 rule R. And second, my lord, they have also challenged 29/5/2025. Either they have to file separate petition, my lord, one is appeal, one is revision, my lord. And so far, my lord, that injunction stays concerned, my lord. Lordship, last objection is very much
Mr.
clear.
Counsel, Mr. Counsel.
Well.
There is an injunction order passed. He filed an appeal under order 43 rule 1R.
My lord,
The order passed in order 43 rule 1R
my lord.
merges, thereby the injunction order which have been passed is being confirmed. So here he is under 227
My lord.
challenging that order of merger
Well.
along with the consequential, the order which merged
My lord. Yes, sir.
together. So why does he have to challenge two?
My lord, kindly see that.
No, I'm not going to see that.
That
So we
definitely
need to
lordship
state.
that now the on the face of the, my lord, record, the order is 29/5/2025.
You have not paid court fees and where is the question of, you have not paid court fees and you want to do all these things. Nothing doing. This type of injunction orders cannot survive.
Injunction part is concerned, my lord, let the first appeal be converted in a way of, my lord, 41, whether
I am exercising 227.
227 lordship absolute power, my lord. There is no
Hmm.
well to that effect. Question is that, my lord, that they himself made it a, my lord, appeal, my lord.
Who?
They, my lord, page 20, my lord, kindly see prayer part.
Hmm.
Prayer part, they have said that the both order has to be put on the challenge in this own revision, my lord.
Where will he challenge?
Yes,
Okay.
page 20, my lord.
Because he's bar, there's a bar. There's a bar for him to file a second appeal here.
Exactly. That's why my lordship first has to answer the issue of 29/5/2025 or that judgment pass, order passed by the learned appellate form first below.
So that is
And
wrong.
so far, my lord, injunction part is concerned, lordship wants to consider as a part of state. Then we have given a chance for hearing, my lord. There is no any urgency, nothing will happen
Hearing.
today, my lord.
You are enjoying an injunction.
No, my lord, we are enjoying, we have been restrained, my
What
lord.
is the
because
injunction order
Lordship
passed?
kindly see- that has been restrained earlier, my lord, again by the appellate forum below, my lord.
Where is
Without-
the injunction order?
Yes, my lord.
Yes, my lord.
That is at page 53.
Lordship, hear us, my lord, without
An
giving
order
us
of
an
payment
opportunity
is
of hearing.
passed against the opposite firm, restraining them from using the name Eksaran Bhagavati till the disposal of the dispute between the parties. My goodness, on the name.
Yes.
You are using it. So both parties shall not use. Eksaran Bhagavati.
My lord, if Lordship wants to hear this issue of, or my lord, stay of the injunction, Lordship at least.
How much time we need?
No, my lord, right now we're dealing with the, my lord, effect of that pecuniary.
We said that both parties should not maintaining the,
What, my lord?
that both parties should not use Eksaran Bhagavati.
My lord, we are, my lord, statutorily, my lord, allowed to be used, my lord. How they can restrict because somebody has put a, my lord, same name. My lord, we have registration, we have constitution, we have everything, my lord, that has been recognized as Society Registration Act.
But it is clouded.
Let them say in a single document, my lord, in their favor, my lord.
But your suit, you have not paid the court fee.
My court fee is an issue that has been raised right now, my lord. That
Not
is not
raised
issue.
right now.
My
There
suit
is
now,
not
my lord,
there.
that will be looked into by the trial court, my lord. On next date, we'll pay the court fee, my lord. Till that
No.
record has not been remanded back, my lord.
No,
Where
no,
will we pay,
you
my lord?
should stay.
Lordship-
Directing both parties to maintain, don't use Eksaran
No, my lord,
Bhagavati
lordship,
Samad.
can speak for a moment. It creates a more panic for you.
That order-
It
that
creates a
order
more,
should be stayed.
lordship create a more panic situation. If lordship wants to hear, lordship first dispose of this matter.
But tell me why I'm not on that. This, I can convert it. I'm only on the question is, once there is a direction of remand passed by this court,
My lord, that is a core issue, my lord.
should the court there
Exceeded the limit, my lord.
consider something which was not there the case of either of the parties?
Yes,
My lord,
and order section 21 is also there. I raised section 21 also, because that point was never raised earlier when the appeal was there. And never raised before High Court also. And nobody's case was there that this court has no pecuniary jurisdiction. Even then, court
No,
so
but would section 21 come into the case in the appeal?
No.
revision appeal also, ma'am.
No. It should have, section 21 says that it should be taken at the first
First
instance.
instance.
Yes,
That is the law.
that is the first instance, my lord. Because appellate jurisdiction is the first instance.
The trial
Because
court is the first
Had it been before the trial court has ample jurisdiction. So far pecuniary jurisdiction is concerned. And in the appellate court, the pecuniary jurisdiction is 20 lakh. So that court is the first instance for the appeal is concerned.
My lord, the language
That's
is
why
this way.
I raised this section 21(2).
Lordship, 21(2) is very important, says, no objection as to the competence of a court with reference to the pecuniary limit of its jurisdiction shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance. How he can say, my lord, the first instance, the appellate form to be raised, my lord? Section 21(2) is very much
So,
clear.
On both the count.
An objection to be recorded on, my lord, in that proceeding, my lord. Therefore, law is something else, my lord. Let's see, lordship may first convert it, my lord. Let the matter be fixed for
How
hearing.
can I convert it?
What
No,
convert,
if
sir?
lordship
The
desire, no,
moment I convert it, the problem is not there for converting. If there was no order of remand by this court,
my lord.
the question of converting is not a problem. I could have.
Yes.
But the moment that when this is the second round,
Yes.
when the court was to only decide on the question of maintainability of the
Yes,
appeal, and you never raised the issue of maintainability on pecuniary jurisdiction,
Absolutely,
and the court directed him to only decide the two.
my lord.
So these two aspects of the matter has been directed to be decided.
Right.
Then once the direction has been given by this court, the court there did not go into all these
repeatedly,
things
my
and
lord,
decided
repeatedly-
this.
repeatedly-
There is the problem
my lord,
arises.
repeatedly raised this issue that there is a limited direction given by the higher forum to deal with the subject matter. Therefore, better to confine it out. But
But to go
despite-
into that question is that,
Yes.
that is the reason why I'm more concerned.
Yes.
I'm not otherwise concerned. If this would have come for the first time, I would have immediately converted it.
yes,
But wouldn't it be showing or overreaching on the orders
Absolutely.
passed by this court?
absolutely.
That is the only worry I'm on that, nothing
that-
else.
that
No,
amounts
it
to an
is a case, my
overreaching.
lord, where my lord
It-
direction has
It's a
been.
case of overreach.
Yes, overreach.
He should not have gone into that issue when it was never issue of either of the parties.
Quite right. Quite right. We raised this issue even by the both side that the limited issue is there, and even that was hard and long
And
for the
even
last
when,
1
madam,
year.
I have submitted my written argument. he heard it. I submitted my written argument. Then he taken the
Where is this court?
in Guwahati.
Additional, district and session judge, court number 1, madam.
Chalo. Yes. Heard Mr. Jason. You should notice making it returnable on 23rd of July 2025. Mr. Essa Maria, who is on caveat. You're on caveat
Yes, madam.
or no?
Yes, caveat, okay.
Caveat isn't it?
Yes, madam, caveat.
And caveat appears on behalf of the respondent numbers 1 and 2. Full stop. Extra copy of the application, present application be served upon him within 2 days. Full stop. The petitioners herein have assailed the order dated 29/5/2025, whereby the appeal being Miss Appeal number 4/2023 was dismissed by the Court of the Additional District Judge number 1, Kamrup Metro at Guwahati on the ground of pecuniary jurisdiction. Full stop. It is relevant to herein to take note of that the Miss Appeal number 4/2023 was earlier disposed of by the court of the by the said First Appellate Court by an order dated 25/8/2023, whereby the appeal was allowed, and thereby the judgment, the order dated 21/2/2023 passed in case number 1179/22 by the Court of the Civil Judge number 1, Kamrup Metro at Guwahati was set aside. Being aggrieved, a proceedings under Article 227 of the Constitution was filed before this court, which was registered and numbered as CRP number 138/2023. Full stop. This court, by an order dated 14/3/2024, disposed of the said proceedings being CRP number 138/2023, thereby interfering with the order passed by the learned First Appellate Court on the ground that the learned First Appellate Court failed to take into consideration the issue of maintainability of the suit, which was raised and they failed to take into consideration the other issues apart from the maintainability of the suit which was raised. And further, that the learned First Appellate Court failed to take into consideration the other two principles for grant of injunction apart from the prima facie case. This court further, by the order dated 14/3/2024, specifically directed the learned First Appellate Court to decide afresh the said appeal, to decide the appeal afresh on the aspect, on the legality and validity of the injunction order passed by the learned trial court. However, in doing so, it was also specifically mentioned that the points which have already been decided by this court cannot be again agitated and decided by the learned First Appellate Court. Full stop. It is surprising that the learned First Appellate Court, instead of deciding in terms with the directions so passed by the order dated 14/3/2024, went into an aspect which was neither the case of the petitioner or the respondents. it has been duly submitted by both the councils before this court, who had duly made submissions before the learned first appellate court. That that appropriate submissions were made also to the effect that the learned first appellate court ought to have considered, in terms with the directions passed by this court dated 14/3/2024, to decide the appeal afresh. However, the learned first appellate court only decided the appeal, dismissed the appeal on the question of pecuniary jurisdiction. Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner, further submitted that in terms of that the learned first appellate court further failed to take into consideration the provision of section 21(2) of the code, which categorically stipulates that if the objections to the pecuniary jurisdiction is not taken at the first instance, the same cannot be raised at a later stage. The learned counsel submitted that this very aspect was also not taken into consideration. Taking into account the above, this court will pass taking into account above, that as the matter is being noticed above, this court has issued notice today and thereby fixing the matter on 23rd of July 2025, on which date the matter would be further heard.
Till then, my lord, the injunction order.
My lord, I have strong objection.
No, my lord, by that
Appeal
time,
is no more in existence as on date. my
if
lord.
the order is not stayed, my lord, then there will be the application for.
It has been
violation.
continuing from 14/3/2024 till date. It can wait till July.
Yes, my lord.
My lord, that violation petition will be filed, ma'am.
Oh,
They will file the violation. Already they have filed the
are you
violation.
saying that you are violating the order?
They will file the
No,
violation.
no, are
petition.
you saying that?
No, not even.
Then don't
no,
worry,
My
you are
lord,
not
that
violating.
status quo till then, my lord. makes
What
sense.
status quo?
Appeal
There
is
is
not
no
there, my
status
lord.
quo.
Till that, no appeal is there.
The injunction ordering that you cannot use this.
Yes, then both parties should not be used at then, my lord.
We'll see you in the matter
My lord, let 23rd, my lord, matter be heard.
on 23rd.
Yes, my lord.
My lord, if that order is not
My
passed.
lord, last
my lord,
occasion also, my
my
lord,
lord,
by
that order is not passed, my lord, then there will be complication again. my
no,
lord.
nothing complication is there.
Already in absence of that, my lord, they filed that application for violation of injunction, man. That is pending, my lord.
Don't worry, I'll take care of it.
Yes, my lord. Deputy Obey.
On next day.
That, my lord, that in a specific direction may be passed, my lord, that no such application should be filed, my lord.
My lord,
Regarding.
That is giving you with impunity to
In the
violate.
meantime, my lord,
privilege they want, my lord.
No, don't worry, I'll take care of it. On 23rd, I'll pass that order.
Yes, my lord.
Because this order, I told them, a copy of the present order be sent to the learned first appellate
Yes, my
court.
lord. Better to. Deputy Obey.
What is this?
So here an application under section 8 was filed. There was this arbitration clause, but that was dismissed by page 51. The respondent, they filed a civil suit, they were a franchisee of the petitioner, and the franchisee was terminated, and thereafter they have challenged that in a civil suit. The franchisee agreement contained a clause of arbitration clause.
My lord, just a minute, lord. My lord. I am for the respondent. They have supplied me copy. Some pages are missing, my. I requested my friend to,
I'll correct it. One page is missing, page 55.
the other pages are also missing.
No, that pagination is correct. I'm challenging the order at page 51.
the suit?
Suit, my lord, will be plain, lordship will find from page 21.
What is your cause of action against the defendant number 2?
I have submitted bank guarantee against the franchisee. And after termination of this franchisee, they have issued a letter to the bank
Invoke the bank guarantee.
to invoke the bank guarantee in full, not in part.
Oh, that's a different thing.
No, no.
But the question is invoking the bank guarantee will come within the ambit of the arbitration clause itself. You can go under section 11.
No, that's why they have filed the petition under section 9 of the Arbitration Act. When the arbitration clause is there, the Honorable Civil Court is.
Who is the plaintiff?
I am plaintiff.
Oh, so therefore, the question is for you to move under section 9. You should have moved my application under section 9 instead of filing the suit.
No, I have filed the suit because other party bank is also there.
Bank
was-
is there,
bank
but
was
bank
there.
has nothing to do.
Bank was not party to the agreement.
Bank has nothing to do out here. Bank is only providing a bank guarantee because you have asked the bank to provide a bank guarantee to support it. Now the question is not that to the effect that the bank guarantee should have been issued or not. This is bank guarantee is not the question as to whether you should have submitted a bank guarantee is not the subject matter. The subject matter is as to whether there should have been a termination or not. That is the subject matter.
Clause
Subject
8 of
subject matter is also there. Because the bank guarantee was co-terminus. As soon as the franchisee is terminated, then the bank guarantee also has no power, no value. Even thereafter, they filed the petition, a letter to the bank for invoking the bank guarantee.
Where is the bank guarantee?
bank guarantee is not a part of the report. Lordship will kindly see the agreement.
Huh?
Kindly see the agreement, franchisee agreement.
Where is that?
Starts from page 14.
Page?
Page 14. This is the agreement of 8 September 2009. Here Lordship will see page 16, clause 8, 9 and 10 which relates to the bank guarantee.
Irrevocable bank guarantee. Well, as security for the sum year. Hello, set aside.
And the arbitration clause is clause 13, page 19.
My lord.
We interfere with it.
My lord,
Heard Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner, Mr. R. J.
RKJ.
The learned counsel who appears on
My
behalf
lord,
of
my
the
submission is there. Then the bank is also a party.
bank is the party. I know the judgment of Sukanya Holdings.
Sukanya Holdings.
Yes, Sukanya Holdings will come, but this is not a question that you have any other thing. It's an irrevocable bank guarantee,
No,
which has
then
nothing to do.
No,
Now,
then-
if you have, you move on to
no,
section
then
9.
the bank sell the court and terminus with the franchisee. Then thereafter, how they can.
No,
send
no, no,
the
it
letter to
it
the
does not
bank?
say, it doesn't,
Yes,
the
my lord, it is
duration of
good.
the agreement.
No, it
will
is
be
a co-
coterminous with the duration of the bank guarantee.
Yes.
In the event of failure of the buyer to take steps to renew the bank guarantee 1 month time before its expiry, the company shall be entitled to invoke it. The further the bank guarantee can be invoked at any time by the company or for any violation whatsoever in the agreement, the invocation of the bank guarantee will be only without prejudice to the rights of to terminate the agreement. Nothing. Who appears on behalf of the respondent. First, the petitioner herein have invoked the revisionary jurisdiction of this court under section 115 of the code, challenging the order dated 16/3/2016, passed by the learned court of the civil judge Punitpur at Tejpur in Mize case number 649/2013, arising out of title suit number 30/2012, whereby the application filed under section 8 of the Arbitration and Conciliation Act 1996 was rejected. Full stop. It is relevant to take note of that the petitioner herein, the respondent herein, along with the petitioner herein had entered into an agreement with the respondent number 1 herein dated 8/9/2009, whereby the respondent number 1 herein was appointed as an exclusive dealer/retailer of the petitioner herein for sale of its range of ready-made garments sold under the brand name Cotton Country in the territory of Main Road, Dhekiajuli, in the district of Sonitpur, Assam. Full stop. Agreement contained various clauses. Full stop. Relevant herein to take note of clauses 8, 9, and 10, which relates to furnishing of an irrevocable bank guarantee of a nationalized bank/reputed private bank by the respondent number 1 herein in favor of the petitioner. Full stop. Further to that, the said full stop. Clause 8, 9, and 10 of the said agreement being relevant is reproduced herein under page 16 of this. Full stop. It is further relevant to take note of clause 13 of the said agreement, which is the arbitration clause. Full stop. Clause 13 of the said agreement being relevant is reproduced herein under. Full stop. The record reveals that the dealership, the agreement dated 8/8/2009 entered into by and between the petitioner and the respondent herein was terminated, isn't it?
Yes.
Terminated. And thereupon, the bank guarantee was invoked by the petitioner.
My lord, condition 12/18, it can also be seen. They themselves have violated. They have not taken back the goods.
It's okay. But here they have terminated the agreement.
They terminated from my side.
have been terminated. And thereupon, the bank guarantee so submitted by the respondent number one herein was invoked by the petitioner.
No, they filed petition, a letter, but it was not invoked.
They had invoked. However, the proceeds of the bank guarantee was not was invoked by the petitioner. Full stop. It is under such circumstances a suit was filed by the plaintiff, by the respondent number one herein, before the court of the civil judge at Tejpur, which was registered and numbered as title suit number 30/2012, seeking declaration of rights and status of the plaintiff oblique the respondent number one herein upon determination of the retailship oblique franchisee with effect from the expiry of 15/8/2012 in terms with clause 12.18 of the agreement dated 8/8/2009, semicolon, for mandatory injunction obliging the petitioner herein to purchase the stock of goods kept at the showroom as provided by clause 12.18 of the agreement, and thereupon furnish a true statement of account of the dues for enabling the plaintiff oblique the respondent herein to make further payment upon reconciliation, semicolon, to restrain and prohibit the defendant number one oblique the petitioner herein from invoking and enforcing the bank guarantee as sought from him by them, semicolon, to restrain and prohibit the defendant number two, that is the bank, from making any payment against the bank guarantee as falsely and unlawfully claimed by the appellant, by the petitioner herein, and thereupon requiring the defendant number two bank to release the plaintiff's fixed deposit receipts offered as security, etc. Pursuant to the filing of the said suit, an application was filed under Section 8 of the Arbitration and Conciliation Act 1996,
They filed the petition under section 9.
not 8.
Section 9, but the contents is referring to the arbitration under section.
Section 9, no, yeah. Well,
The
was
first time they
filed.
mentioned it as section 9.
was filed
Section 9.
under
is
Section 8.
President rule 11.
Filed Section 9
For rejection of plan.
Paragraph 3 and 4 of the Constitution, page 40.
had filed an application under Section 8, Section 9 of the Code of Civil Procedure for rejection of the plaint, as the suit was barred under Section 5 and Section 8 of the Arbitration and Conciliation Act 1996, on the ground that on the ground that the agreement entered into by and between the petitioner as well as the respondent number one dated 8/9/2009 contained an arbitration clause in clause 13, that is clause 13. First, objections were filed to the said application by the plaintiff oblique the respondent number one,
Page
Full stop.
47.
the learned trial court, by the order dated
16/3/2016.
16/3/2016, rejected the said application, and it is under such circumstances the present proceedings have been filed. This court have duly taken note of the reasons assigned by the learned trial court for rejecting the application. Full stop. The first reason is that the defendant number 2, which is the bank, was not a party to the arbitration agreement. The second reason is that the arbitrator would not have the power to pass orders of prohibitory and mandatory injunction as has been sought for. And as such, the application which was filed by the petitioner, oblique the defendant number 1 in the suit, was rejected. Full stop. Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner, submitted that though the said application was mentioned as an application under Section 9 of the Code of Civil Procedure 1908 and have also referred to Order 7 Rule 11D of the Code, but in a sense, the said application was an application under Section 5, under Section 8, read with Section 5 of the Arbitration and Conciliation Act 1996. He submitted that the reasons so assigned by the learned trial court in rejecting the application is completely misconceived, taking into account that a very perusal of the suit would show that the plaintiff oblique the respondent number 1 herein had no cause of action insofar as the defendant number 2 is concerned. The entire cause of action relates to the dispute between the petitioner herein with the respondent number 1 herein. And the said dispute had to be resolved by way of an arbitration clause, which is already contained in the agreement. Any judgments?
Pink City. Hindustan Petroleum.
The learned counsel appearing on behalf of the petitioner have referred to the judgment of the Supreme Court in the case of Hindustan Petroleum Corporation Limited versus Pink City
Pink City Midway
Petroleum, reported in 2003, 5 SEC, 6 SEC,
503.
503, and submitted that the learned first trial court ought to have and submitted that it was obligatory on the part of the learned trial court to refer the parties to arbitration, and thereby the suit ought to have been dismissed. Per contra, Mr. R.C. Jain, the learned counsel, on behalf of so and so, appearing on behalf of the respondent number 1, submitted.
There is one also, the allegation of fraud is also there. When the allegation of fraud is there, then arbitration clause would not come into picture.
Submitted that the question of referring the dispute to arbitration did not arise, taking into account that the disputes which is sought to be resolved could not have been resolved by way of arbitration on the ground that there were allegations of fraud. He further submitted that as the defendant number 2 was a party in the said suit, and the Code of Civil Procedure that do not permit bifurcation of the suit, the question of referring the dispute to arbitration does not arise, and in that regard referred to the judgment of the Supreme Court in the case of Sukhenna Holdings versus so-and-so, reported in 2023, 5 SEC, page
531.
541.
531.
Sukhenna Holdings versus
Sukanya Holdings Private Limited versus Jayas H. Pandya.
Yes.
Okay.
In this regard, our High Court judgment is,
Huh?
our High Court judgment is there.
Which one?
Two judgments are there. Particular realtor.
Hmm?
2010 4 GLT 137,
Name?
Kamputra Realtors Private Limited, GG Transport. Private.
What does it say?
It says that the one who is not the party to the agreement,
That is already there, Sukanya Holdings. Then,
both the judgment has relied on the Sukanya.
so these, it's okay. So that judgment not required. You want it?
Yes, ma'am.
Chalo. He further relied upon the judgment of the coordinate bench of this court in the case of,
In the case of one is Sadhuram Agarwal versus Sadhuram Agarwal.
what does
Ramanath,
it say?
Same, it says that when the parties.
Mr. Jain, I'm telling you, don't unnecessarily make it long, making it those judgments. These, if you are having some other point, come in, because you already have a Supreme Court judgment for that, Sukanya Holdings. And these judgments are following Sukanya Holdings. So therefore, you don't need to repeat it. Do you have any judgments on anything else apart from that on fraud? Do you have any judgment on fraud?
Judgment concerned to the agreement was challenged, the agreement was.
That is another thing. When an agreement is challenged, is a different aspect. I'm saying, do you have any judgment on fraud? When a fraud is there, then arbitration agreement cannot happen.
It is Madras High Court.
Where is that judgment? I.S. Swami, 2016, Supreme Court judgment, 2016, 11 SCC.
That I don't have, I am relying on one more Sundaram Finance Matter where it has been said that when the question of section 8 comes, the court must have to see whether it has jurisdiction or its the jurisdiction is ousted.
That is has been also said in Vidya Drolia, 2023.
This
Where
is
is that?
2015.
No. Where is that judgment? Vidya Drolia? I.S. Swami? Okay, having heard the learned counsels appearing on behalf of the parties, let this court now consider as to whether the learned first trial court was justified in rejecting the application filed seeking dismissal of the suit on the ground that there was an arbitration clause. Pusto. This court finds it relevant to take note of the judgment of the Supreme Court in the case of P. Ganpati Raju. Where is that? 2004 SEC? Give me that Pink City judgment.
Pink City.
There, it is quoted. The Supreme Court in the case of P. Anand Ganpati Raju versus P.V. Raju reported in 2004 SCC 539, wherein the Supreme Court made it clear that the language of Section 8 is preemptory in nature. Pusto. It was observed that in cases where there is an arbitration clause in the agreement, it is obligatory for the court to refer the parties to arbitration in terms of the arbitration agreement, and nothing remains to be decided in the original action after such an application is made, except to refer the part dispute to an arbitrator. Full stop. This court further finds it relevant to take note of. Full stop. In the backdrop of the above, let this court consider as to whether there has been any allegation of fraud which is of such nature that the arbitrator would not be in a position to decide. Full stop. It is seen from a perusal of the plaint, more particularly at paragraph number 8, there is a reference that the defendant number 1, who oblique the petitioner herein, had chose to commit a fraud on the defendant number 2, that is the bank, by demanding upon it to pay the maximum guaranteed amount of rupees 7 lakhs. Full stop. The question therefore arises as to whether the such allegations contained in the plaint would have been taken into consideration by the can be adjudicated by the arbitral tribunal. The Supreme Court, in the case of A. Ayaswamy versus A. Paramasivam and others, reported in 2016 10 SCC 386, observed that if the allegations of fraud can be adjudicated upon, that mere allegations of fraud simpliciter may not be a ground to nullify the effect of an arbitration agreement between the parties. It is only in those cases where the court, while dealing with an application under Section 8, finds that there were serious allegations of fraud which makes a virtual case of criminal offense, or where allegations of fraud are so complicated that it becomes absolutely essential that such complex issues can be decided only by the civil court on an appreciation of voluminous evidence that needs to be produced, the court can sidetrack the agreement by dismissing the application under Section 8 and proceed with the suit on merits. First, the concurring judgment delivered by His Lordships, D.Y. Chandrachud J., as His Lordships then was, observed that allegation of fraud are not alien to ordinary civil courts. Generation of judges have dealt with such allegations in the context of civil and commercial disputes. If an allegation of fraud can be adjudicated upon in the course of a trial before an ordinary civil court, there is no reason or justification to exclude such disputes from the ambit and purview of a claim in arbitration. Full stop. These observations so made by the Supreme Court was also confirmed by a three-judges bench of the Supreme Court in the case of Vidya Drolia versus Durga Trading Corporation Limited, reported in 2021 to SEC 1. Taking into account the above, it is therefore the opinion of this court, and taking into account the above settled principles of law, and having perused the plaint, the allegations of fraud so made are not of such a serious nature which cannot be adjudicated by an arbitral tribunal. Full stop. Next question which arises is on the question of that the defendant number 2, which is the bank which had issued the bank guarantee, irrevocable bank guarantee, favoring the petitioner herein, was not a party to the said dispute, to the said agreement dated 8/8/2019. And as such, by virtue of the judgment in the case of Sukhoina Holdings, Supra, the learned trial court was justified in not referring the parties to arbitration. Full stop. This court finds it very relevant to take note of that a perusal of the plaint would show that there is no cause of action against the defendant number 2 of the plaintiff. Full stop. The defendant number 2 had issued an irrevocable bank guarantee on the basis of the agreement entered into by and between the plaintiff as well as the defendant number 1, plaintiff or petitioner or plaintiff oblique respondent number 1 with the defendant number 1 oblique the petitioner herein. First, under such circumstances, the question of bifurcation of the suit does not arise as the plaintiff does not have any cause of action against the defendant number 1 separately. In that view of the matter, it is therefore the opinion of this court that the learned trial court was not justified in rejecting the application for referring the parties to arbitration. This court further finds it, accordingly, this court therefore allows the application being Mise case number 49/2013, and thereby the suit stands thereby referring the parties to settle their dispute by way of an arbitration, and the suit being title suit number 30/2012 stands dismissed. The dismissal of the suit, however, is without prejudice to the rights of both the parties to the suit to agitate their grievances before the arbitral tribunal, if so advised.
His case number would be 48 of it.
There was one injunction petition also. In the injunction petition, the learned trial court asked me to pay them 2 lakh rupees, which is admitted them. and rest of the amount it was still.
So these you find it out how to do it. You file section 11. File section 11. You get the injunction. There are numerous of injunction. Yes, what is this?
Public.
Chalmai Tea Company.
Item 5.
What is this?
Petition amendment was rejected, Lordship.
Ah,
Page number 30 is my petition under order 6/2/17. Lordship.
this company in existence?
Lordship.
Sure. The other side.
Lordship, the last date also they did not appear. Lordship.
Where is that order?
Page number 40. Lordship.
What is the injunction you have sought for? What is the order amendment you sought?
Lordship, 3 amendments, page number 30 may be seen.
Page number?
30, Lordship, my petition is at page number 30. 30. Change in address, Lordship,
Want the
paragraph.
change is demand? You want the change in the- Why was it rejected? Why did you file it so late?
It's not in our knowledge, Lordship, but then.
How
thereafter
can
when
it
the
be
man-
without your knowledge?
when the mandatory provisions come, was first the records, Lordship. Then only he got to know that the resolution was not filed, Lordship. And thereafter he has taken steps to amend the petition, Lordship.
What?
And even the prayer for profit also, Lordship.
Huh? So this will again, now the suit will go back. How can we allow these amendments? Only the amendment of changing the name.
Address, Lordship.
Name can be only permitted, otherwise there is nothing else.
Lordship, for the profit prayer, Lordship.
You didn't ask for that.
Lordship, we had stated that they are
This you
coming
filed it when in 2016?
7.
16. So if you have filed this in 2016, it is already barred by limitation. You want now to bring it from the date of when the suit is being filed. We can't allow. We can only allow the name.
We plucked the tea leaves, Lordship, from our garden. And only for the prayer portion, we had invest for praying the prophets. Lordship.
Isn't it barred by limitation? If it is barred by limitation, how do I permit this? Tell me, give me a good idea. This can't happen. These people are out, still in possession. The suit for recovery.
For cancellation of the sale deeds, Lordship. And see, they have taken possession and illegal construction also they have made.
And when did you purchase this tea garden?
Lordship, we have purchased the tea garden
Tea company?
1983, Lordship.
No, no, no. Registered as well as the head office Surveillance had changed. So this you want to change it. It's okay. But when did this happen?
Not there, Lordship. Petition.
Then
Instructions.
how
regarding
do I help you? At the end of the day, you are doing this. On the date of arguments. Then
the knowledge that these things have not been changed.
so we will allow, I can only allow the amendment sought for in paragraph number 3. The remaining remains as it is. Show me the plain. Suit for declaration, cancellation of the sale deed, so and other reliefs. 2 lakh. For declaration and recovery of possession, 2,50,000. And now you want to add 20. And thereby it will go outside the jurisdiction of that court. Huh? What? Now, this evidence you must not have given, page 34. When you adduce evidence, this must have been the question. So now you want to put this and now bring the suit back to that stage? Yes. Then you only allow paragraph 3.
Lordship.
Heard Mr. Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Nath has appeared on when the matter is being taken up. The petitioner have invoked the supervisory jurisdiction of this court, challenging the order dated 17/1/2017, whereby the application filed under Order 6, Rule 17, read with Section 151 of the Code, which was registered as Media Case Number 100/2016, was rejected. This court have duly taken note that the said application was filed at the stage when the suit was fixed for arguments. First, it is further relevant to take note of that by way of by way of the said amendment application seeking amendment, the plaintiff sought for change of the sought for amendment as mentioned specifically in paragraph number 3, 6, 7, and 8. This court have duly taken note of the order passed, order impugned in the instant proceedings, that is the order dated 17/1/2017, whereby the learned trial court had rejected the amendment application on the ground that there was no due diligence on the part of the petitioner. First, this court have also, this court having taken into account the reasons so recorded, do not find any good ground for interference under Article 227 of the Constitution. Be it as it may, this court finds it relevant that there has been a change in the address of the petitioner company, that is the plaintiff company. During the pendency of the suit, the same would have certain ramification if the suit is if the suit is decreed in favor of the plaintiff. It is also the opinion of this court that if the address of the plaintiff is allowed to be changed, comma, it shall not cause any prejudice to the respondents. First, accordingly, this court is of the opinion that the amendment application can be allowed only to the extent of what has been sought for at paragraph number 3 of the said amendment application. First, it is clarified that this court have rejected the amendments so sought for at paragraph number 6, 7, and 8 of the amendment application. First, taking into account the above, comma, this court therefore disposes of the instant proceedings, thereby with the following observations and directions, comma, the amendment sought for at paragraph 3 of the application seeking amendment being Ms. case number 100/2016 stands allowed. Full. The amendment which have been sought for by paragraph numbers 6, 7, and 8 of Ms. case number 100/2016 stands rejected. Full. It is noticed that by an order dated 6/2017, the further proceedings of CRP case further proceedings of title suit number 4/09 was stayed. The said stay order stands vacated, and the petitioner is directed, who is the plaintiff in the suit, is directed to produce a certified copy of the present order, and the learned trial court, that is the court of the civil judge, Tinsukia, senior division, Tinsukia, shall, on the basis of the instant order, make necessary correction, direct the solicitor of the said court to make necessary correction in the cause title of the plaint by hand by inserting the amendment so allowed in paragraph number 3, amendment so allowed, that is paragraph number 3 of the plaint of the amendment application. Full stop. The above the instant proceeding. The next date of this court fixes the next date before the learned trial court on 14th of July 2025. Full stop. Taking into account that the respondents are not represented, the learned trial court shall proceed with the disposal after duly informing their respondents.
Fixed at 2 p.m.
Please, my lord. My lord, can it be taken after some time? My lord? Can it be taken after some time?
Why?
My senior Mr. S.P. Chaudhary is left in court number 12 now.
No. Has to be taken now. Because every time this matter is being listed, nobody appears. That is why I have put this at 2 p.m. What is that? We have failed to take steps upon the respondent number 3 within time prescribed. No further extension of interim order would be done. Interim order has been vacated. Now what happens? What are you challenging?
My lord, actually, the petitioner, as PW1 adduces evidence on affidavit, they were exhibited several documents, but have not exhibited it in the form of an original. They have not produced the original document. So you mentioned in the affidavit, producing the evidence in the form of an affidavit, the petitioner has mentioned few list of documents. But though he have mentioned it, but those documents were never been exhibited by him. So our prayer was to consider through re-examination that my prayer for allowing me to submit the original documents and consider it to be as a part of record was not considered. That is.
You have been asked to take certified copy of the documents required from the circle officer, and also record reveals that there is no such document submitted at the time of PW which is required to be proved by the said official witness. As such, I do not deem it proper to allow issuance of summons to official witnesses, since the same would only amount to delay the matter. Then, what is your petitions for? 455. Certain documents needs to be proved by the official or the imam, and accordingly plaintiff has paid for issuance of summons upon so and so. Defendant in the returns submitted, there is no necessity of examination of the official witnesses since the documents were not exhibited by the plaintiff at the time of PWs. Accordingly, plaintiff has prayed for dismissal, defendant has prayed for imam. What you are challenging, which order? Order of 21/5/2018 in respect to words, thereby rejecting the right to produce exhibited documents for judicial notice by way of re-examination should not be set aside. Which is the petition for that?
Yes, my lord, page number 21, petition annexure 3. PW1 for tendering or producing the exhibited documents.
It's not a case of re-examination, it's a case of recalling. This is a case of re-examination. Re-examination will happen when there is a question of what you call he has been cross-examined and then you re-examine. This is a document which you did not produce at the time of cross-examination, plaintiff evidence in chief. So you want to bring these documents. And for proving that documents, you want to do it by way of recalling the witness, isn't it?
No, what was that, though I have mentioned in my evidence, the list of those documents, but that list of documents, I have not exhibited.
Where have you mentioned in your in your exhibit, yeah? Yeah, evidence on affidavit.
21 annexure 3.2, that at the time of educing his evidence, PW1 in the evidence on affidavit, the relevant documents which were annexed with the claim were mentioned as exhibited documents, but inadvertently those exhibited.
But you did not place these documents.
That is,
This is petition number? This one.
969.
There was a stay granted.
Yes, sir.
So there will be now again the cross-examination.
Yes, sir. Yes, sir.
Now service is not complete against whom? What has happened after I have vacated the interim order? then you don't know anything. Fellow, we dismiss on the ground that you don't know anything.
Let my senior be present. Let my senior be present.
He's not present. He knows at 2 o'clock the matter was fixed. So we dismiss it on that ground. You did not make these people official witnesses also. Did you give the list of documents, a list of witnesses?
We have given list of witnesses, and accordingly we have filed our evidence in the form of an affidavit.
You are not in connection with the petitioners now. None appears when the matter is taken up. It is seen that on earlier occasions also, in spite of various in spite of various opportunities given, no steps was taken upon the respond number 3. Consequently, it appears that the petitioner is not interested in the instant proceedings for which the instant petition stands dismissed for non-prosecution. Can't help it. You have a case, but they can't help it if you don't know. You cannot take the advantage of this.
After some time,
No, because whenever the matter is otherwise listed, otherwise, if it goes after 4:30, you are not present. And therefore, I had to fix it at 2 p.m. And if I allow your petition, I will impose a cost of 50,000 upon the council. That day, there is a council who filed an application and the petition was not properly done. I imposed 25,000 cost upon the council, and also said that if he does not pay, it will be recovered from by the deputy commissioner as heir for land areas. This is what you cannot escape them. You have no connection with the petition, get it dismissed. Otherwise, it will be recovered from you.
can it be after some time? And I'll just inform my senior if he can, my lord, press this court with the queries that your lordship is making.
Huh?
I mean, if he can answer to the question, because I'm not aware about those connections.
You are not there in this case.
My senior is appearing on this case.
You are not there.
My name is not reflected though, I'm in the.
Huh?
My name is not reflected in this.
None appears on behalf of the petitioner on court. The matter is taken up. This matter has been taken up specifically at 2 p.m. And in the list also it is shown that at 2 p.m. However, as the petitioner is not appearing, counsel for the petitioner has not appeared, the instant petition stands dismissed for non-prosecution.
Production list item 1 for motion.
As the last item, Mr. Somari.
Admission item 6.
Yes. Very challenging.
Can I explain to you? The impugned order is at page 85. It's an order rejecting my application under Order 7, Rule 11, seeking rejection of the counterclaim. On the ground
Rejection of the?
counterclaim filed by the defendant. Here, respond number 1.
You have sought for rejection of the counterclaim. What is the reason? Ground?
He is seeking cancellation of a lease deed, registered lease deed, and he filed it after limitation period. It is barred by limitation. That is the only ground. So the relevant part is at page 95. Paragraph 32. May I read out? The counter defendant has claimed by para number 20 of his rejection petition to the effect that the counterclaim suit is barred by law of limitation under the provision of Article 59 of Indian Limitation Act. The counterclaimant did not mention in his counterclaim suit any specific date when he gave oral consent. Unregistered lease deed dated 887 and registered deed number so and so dated 978 are the claim of the counter defendant by the plaintiff, which are the mere reference of dates of cause of action only. The effective and real cause of action is in the year 2017 only, when the counter claimant received the copy of so-called lease deed as supplied by the counter defendant in connection with the present suit. Had the counter claimant defendant got knowledge or information regarding the said so-called unregistered and registered lease deed, or had the fraudulently manufacture of so-called lease deeds in the knowledge of the counter claimant defendant, definitely the counter claimant defendant would have filed a suit against the counter defendant by the plaintiff for evicting him from the suit land. But the counter defendant plaintiff has the conspiracy very secretly and tactfully. The villager layman and illiterate counter claimant had no way to know how the lease deeds manufactured and registered. He was completely under the dark. So the actual cause of action for the counterclaim suit is the date on which the counterclaimant defendant received the copy of the so-called lease deed only in the year 2017. As such, the counterclaim suit of the claimant defendant
Where is the plaint?
Plaint is at page 29. It starts from page 20. My plaint. The reliefs are page 38. So the registration of the lease deed is admitted by the sub-registrar who is defendant number 8. And also the putting thumb impression was admitted by the defendant number 1. This is the respondent number 1. Seeking declaration of leasehold rights over the suit land. And the defendant number 1 is seeking cancellation of that lease deed.
Where is it admitted?
Yes, your lordship may kindly come to page 63.
Page?
63. 63.
What is that?
Paragraph 8. This is the written statement by defendant number 8, which is the register, sub-register. So the statement made in paras 4, 5, 6, 7, and 8 of the
Cause of
plaint.
action against the defendant also,
The
that if I
last
had
sentence.
no knowledge about these paragraphs in the above suit, I
Last
will submit that the register was executed before the instrument describing. So,
The defendant submits that a registered lease deed was executed before the sub-register office Bushaigaon on so and so, describing the area of land so and so. This is the categorical statement that the lease deed is executed. And the admission by the defendant number 1 is at page 44.
this is by defend number 8, and
Eight.
we are not concerned with them.
44.
Page,
44. Here is also the last sentence, though fraud and misrepresentation has been pleaded, but there is admission of putting thumb impression. That means knowledge.
page,
Page 44,
paragraph
paragraph 7.
10.
Paragraph 7, last sentence, yes, paragraph
I had
7.
no knowledge about the deeds.
Yeah.
And so and so. It is a fact that the plaintiff put thumb impression on some blank papers also. The deeds as mentioned in here are without the knowledge of the defendant, and they have been obtained from them by making fraud. So,
So, by misconvincing the defendant and other village people, including the Gaobura, the plaintiff managed to obtain thumb impression from them tactfully and by misleading and fraudulent. Though it is, the thumb impression is admitted. The fraud and misrepresentation has been pleaded, but putting thumb impression is.
no, that is a question of fact.
Yes, madam. That is a question of fact and subject to
See,
the evidence.
Article 59 categorically says from the date of his knowledge. So he says his date of his knowledge is the filing of the plaint.
Yes, but this is a registered lease deed, my lord.
So,
So
if it
registration,
is a registered, is it from the date of the registration? Limitation acknowledged. Is it from the date of the registration or date of
Registration is not-
knowledge about the registration?
registration implies that they know because it is the same person.
The question is,
Okay.
has
Okay.
to be, just for example, somebody has done it. Nobody may have known about it. It will have far-reaching consequences if we are to dismiss it. He has a right. Whether it is within the knowledge or not, he had the knowledge or not, these are all questions which have to be looked into.
My lord, registration gives rise to a presumption that the document has been executed. And it implies.
A registration gives a presumption, which is, but it is a rebuttable presumption.
Yes, this is rebuttable presumption.
It's rebuttable. Then
But prima facie,
what primary, you cannot cause the non-suit somebody prima facie.
No.
Yes.
a plain reading of the plaint should show that he has, it is not barred by limitation. He is admitting putting thumb impression, the document is registered and the sub-register is admitting that it is executed. That all. these
Again, you
things
are
like-
bringing the sub-registers thing. We have nothing to do with the sub-register. The counterclaim will be the plaint. Therein, he categorically say, I had no knowledge till the filing of the suit. Limitation Act. Limitation Act. होगा ये तो। Limitation Act. Can you see 56? There the forgery of an instrument issued or registered. When the issue or registration becomes known to the plaintiff. Has to. It is not a question of 59. It's a case of 56. The plaintiff categorically says, the counterclaim categorically says that I have come to know only after the filing of the suit.
That he's a pleading fraud, my lord, and he
Ah.
admitted the thumb impression and he's pleading fraud. So in such case,
Whether
59
he is pleading fraud or not, he had categorically pleaded out there that look here, this thumb impression which is there may have been taken for some other purpose. But I have never been to the registration office. This is his specific statement. He says that he has no knowledge.
may produce a judgment, my lord.
Huh?
Supreme Court judgment where it is held that when it is fraud is produced, Article 59 is applicable.
Where? Which
Fraud is
judgment?
produced. It is preempting and others. Paragraph 18, my lord. Paragraph 13 also. Article 59 of the Limitation Act applies specifically when a relief is claimed on the ground of fraud or mistake. It only encompasses within its fold fraudulent transactions which are voidable transactions. Paragraph 18. Article 59 would be attracted when coercion, undue influence, misappropriation or fraud which the plaintiff asserts is required to be proved. Article 59 would apply to the case of such instruments. It would therefore apply where a document is prima facie valid. It would not apply only to instruments which are presumptively invalid. And then paragraph 20, if the plaintiff is in possession of a property, he is also not in possession. Paragraph 20, if the plaintiff is in possession of a property, he may file a suit for declaration that the deed is not binding upon him. But if he is not in possession thereof, even under a valid transaction, the right by way of adverse possession may be claimed. Thus, it is not correct to contend that the provision of Limitation Act would have no application at all in the even the transaction is held to be void. So mainly paragraph 13 and 18. So clearly, it is stated that Article 59 is applicable.
No, but when he is saying that, what do you say about 56? 56?
It's clearly a case of 59.
Why? Because Supreme Court says so. But I'm asking you, what do you say about 56? Do you have the Limitation Act with you or not? Sorry, state of affairs.
Sorry. May be applicable when the plaintiff is not the party.
Huh?
This may be applicable when the plaintiff is not the party.
What?
Article 56.
Not
When-
a party
when
means?
the forgery, he is not a party to the contract and not party to the instrument.
Why?
Uh,
He himself says that he is not a party to the instrument.
Yes,
He says that I have no knowledge about this instrument.
but the registered document shows that he is party. So in
Oh,
that case,
somebody may very well have registered the instrument fraudulently. Are you therefore going to say that he has no suit?
he has within the limitation period.
But he may not know.
That is he also, my lord.
Then why,
My lord,
why in,
this case,
no, no, Mr. Laskar, can you tell me why the Limitation Act categorically says from the date of his knowledge, both in 59 and 56. 56 also it says, and 59 also. See 59 properly. It says from the date when he has knowledge.
that is there.
Then the question whether he has knowledge or not is a question of fact.
But Supreme Court held it.
Is this the case of Order 7 or 11? Huh?
No, my lord, this is only about the presumption and registration.
Why don't you be extremely careful?
And my lord, he also admitted my possession from 2007.
Yes, you may be in possession. So, therefore, he is asking for declaration of his right, title, and interest also.
So possession also implies that there is a deed, and
How?
so otherwise, how can I get possession? And if I forcibly dispossessed him and got possession, he should have come to the court within the time.
Why? What is the time? What is the time for recovery of possession if it is you are able to prove?
It is 12 years, but
Who says 12 years?
recovery of possession.
Recovery of possession is not 12 years. Once a declaration is being proved, then declaration of his, he has the right over the property. There is no limitation unless you plead adverse. But you are not pleading adverse because your specific case is that you got your right from him.
Yes.
You still say that you are his lessee.
Yes.
Then question of adverse possession does not arise.
We are not pleading adverse.
Then where is the question? Chalo, dismiss. Heard Mr. O. Losko, the learned counsel appearing on behalf of the petitioner, none has appeared on behalf of the respondent on call. The petitioner herein the petitioner herein has invoked the revisional jurisdiction of the court, challenging the order dated 26/2/2019, passed by the learned court of the civil judge Kokrajar in petition number 348/18, whereby arising out of title suit number 09/2017, whereby the application filed under Order 7 Rule 11, read with section 151 for rejection of the rejection of the counterclaim. The counterclaim filed by the defendant number 1 in the suit was rejected. First, the sole ground taken in the said application under Order 7 Rule 11 for rejection of the counterclaim is that the suit was barred by limitation, taking into consideration the ground so taken is that from the statements made in the counterclaim, the suit was barred by limitation. This court finds it relevant to take note of that the counterclaimant, that is the defendant number 1, had filed a counterclaim seeking a decree for declaration of his right, title, and interest over the suit land, semicolon, for a decree declaring that the lease deed number 220/185 dated 9/7/2008 is null and void and the same be cancelled, semicolon, for a decree for issuance of precept directing the sub-register Gosaigaon to cancel the registered lease deed number 220/185 dated 9/7/2008, semicolon, a decree for eviction against the plaintiff from the suit land, etc. Full stop. It is relevant to take note of that the counterclaimant had specifically mentioned that at paragraph number 10 of the counterclaim that he had no knowledge about the arrangement for preparing a lease deed. He further stated that he did not go to the office of the sub-registrar at Gosainga for getting registration of the so-called lease deed. It was alleged that the lease deed was prepared by the plaintiff secretly by making conspiracy. Full stop. It is further mentioned that the counterclaimant had no knowledge about the lease deed, which was it was further alleged in the counterclaim that the counterclaimant had no knowledge about the said lease deed. And only on the date the suit was brought against the counterclaimant, when he came to learn about the lease deed. Full stop. This court finds it very pertinent to take note of that the perusal of Article 656 as well as 59 of the limitation of the schedule to the Limitation Act stipulates that the date is to be reckoned seeking date for a suit for seeking declaration. As regards forgery of an instrument issued or registered, as well as for cancellation of an instrument, comes to the knowledge of the plaintiff for the first time. In the impugned order, the learned trial court, based upon the reading of the counterclaim, had come to a finding that the date of knowledge of the execution of the deed was in the year 2017, when the counterclaimant received the copy of the said so-called lease deed. And as such, it was not barred by limitation. Full stop. Taking into account the provisions of Article 56 and 59 of the Schedule to the Limitation Act 1963 and the contents of the plaint, it is the opinion of this court that the learned trial court was justified in rejecting the application seeking rejection of the counterclaim on the ground that it is barred, on the ground that from a reading of the counterclaim, it cannot be said that the counterclaim was barred by limitation. First, considering the above, this court therefore finds no in exercise of jurisdiction by the learned court of the civil judge, Kukrajar, in passing the impugned order dated 26/2/2019, whereby the petition number 348/2018 was rejected. It is relevant to take note of that by the order dated 10/3/2000, by the order dated
Interim order is dated 26/2/2019. 26/2/2019.
by the order dated 22/3/2023, notice was issued and the LCR had been called for. The calling of the LCR had led to the stay of the suit proceedings. First, accordingly, as the respondents are duly represented, as well the parties are duly represented before this court, they are directed to appear before the learned trial court on 11th of August 2025. Full stop. On such date, full stop, the registry shall ensure that the records of the trial court be returned to the court, ensuring that on the date so fixed, that the records are available before the learned trial court prior to the date so fixed herein before.
Observation made in paragraph 34, my lord, may prejudice the plaintiff. Observation in
So
the.
it is further observed that the observations so made in the impugned order, as well as the observations so made in the present order, shall not prejudice the parties in the during the on merits in the trial of the suit,
Getting the issue of limitation.
including on the issue of limitation. You are appearing for ETC or so and so appears for.
Not shown in cause list, Lordship, but record shows that employment of the party.
You are appearing?
Lordship,
To provide you.
2 and 8 years.
And you are appearing for?
3 to 7.
One is not there.
Item 7.
What are you challenging?
Your lordship, I am paying for accommodation. The conducting counsel is due to immediate emergency is out of station, your lordship. So any date next week he will be there, your lord. He was supposed to come back today, but unable to.
None appears, the counsel appearing on behalf of the petitioner seeks for an accommodation. Just to list the matter after 2 weeks. And so appears for the response.
Interim may be
No,
continued.
if you don't argue on these small matters, I can't extend interim.
8.
The vacation at the deal.
May I please, Lordship? I think in this case,
I am the plaintiff in the original suit.
Hmm.
I have got a decree.
Hmm.
There I have filed a execution case also. In the executing court, while passing the impugn order, held that decree has been already satisfied. It cannot be executed.
Huh?
It cannot be executed.
Satisfaction there cannot be
My
equated with the
suit is
satisfaction of the
regarding
decree holder.
in
If the
respect of
decree
the
is
land.
not executed as per the terms of the decree, then the decree is found to be restrictive of the considering the other activities, the decree is found to be fully satisfied since the Schedule A, which includes Schedule C, is already recorded in the name of the. Yes.
The case is that Lordship may kindly peruse page 13, Lordship. My plain, what is my prayer?
Not,
Sir.
show me the decree, or not the prayer.
Lordship, decree
The
has been passed.
plaintiff suit is decreed on contest,
Plaintiff
but
suit is
without
decreed on
declaring
contest.
his right, title, interest and possession over Schedule C land, along with without cause, without cause, declaring his right, title and interest and possession
Respect of
over the
Schedule C
Schedule
land,
C land,
But the
along
learned,
with the decree of correction of the records of the rights.
but the
Only
learned
for Schedule C land.
C land, Lordship.
Then?
Case is that land measuring 2.8 lessons has been wrongly recorded as khas quotidian number 1. And that may be corrected and a declaration that I have righted the interest in respect of that land.
Schedule C land.
But in the plain Lordship, due to some inadvertent mistake, it should be recorded that land measuring 2.8 lessons recorded as khas quotidian number 1. But it has mentioned that land measuring 2.8 lessons of the Medibatta land. That is
Of Dag number so and so of
So and
quotidian
so.
number 369.
only for that purpose, Lordship. Decree cannot be executed.
Huh?
Otherwise, I have a prayer that a land measuring 2.8 lessons has been wrongly recorded in khas quotidian number 1. But in the Schedule C, Lordship, it has recorded land measuring 2.8 lessons, part of B schedule land covered by Dag number so and so, so and so. It will be there, which has been wrongly recorded as khas quotidian number 1. Because of this,
Quotidian number 369.
369. So 369 is my Medibatta land, Lordship. Out of total land is that 1 bigger 3 kota 12 places of quotidian number 369. Out of that land, a portion of land 2 kotas 8 lessons have been wrongly recorded as khas quotidian number 1, Lordship. That is my case. My case is that should be corrected and a declaration of right to the in respect of that land. Accordingly, decree has been passed, Lordship.
Declaring that the land of Kukatha described in Schedule C covered wrongly recorded as khas in khas quotidian number 1 is the parcel of Dag number Iman in quotidian number Iman and so and so. Decree, but this relief was not granted. Relief 1.
Relief was not granted by Lordship.
Then if the relief 1 is not granted, then what?
That correction of Schedule C land.
Understood. A decree for declaration that the plaintiff has got right, title and interest with confirmation of possession of the Schedule C land. This is given. Decree for declaration in the record in respect of so and so as khas is wrong and liable to be corrected in the name of the plaintiff under Dag number Iman of so and so, declaring that to be a part of the Schedule A land. Nothing given. What to do?
The learned trial court has, Lordship.
Along with the degree of correction of the records of the rights. So that has been given.
That has been given, Lordship. But
Correction of the rights. Now, what is your application?
my in the executing court, Lordship, to execute the decree, Lordship.
Then
Only one mistake, Lordship.
you have not filed any petition.
No petition, Lordship. But the order of the learned executing court is wrong, Lordship. Kindly peruse page 29, Lordship. Now the perusal of the judgment. Now the perusal of the judgment order decree passed in title suit number so and so reveals that the decree will be satisfied only when the wrongly recorded portion of Schedule A land, the Schedule C land is rectified and entire Schedule A land, which includes B, C Schedule land under same drug is recorded in the name of the decree provides that only Schedule C land, Lordship. The learned executing court held that record of correction should be done in respect of Schedule A land, Lordship. decree does not provide that the land records of Schedule C land should be prepared and corrected separately in the name of decree. On the contrary, decree simply provided for correction of record of rights of the Schedule A land, since Schedule C land is a part of Schedule A land. Hence, it is clear that by erecting the record of rights Schedule A land, the decree cannot be executed properly.
Now, why you are asking for 576, 577, 578 to be brought within 579?
In this case, also, in most of the time, many precepts has been issued. Many precepts has been issued because we have filed the agreement in the year 2001. Sometimes there are some record there reveals that there are some dark government dark. The dark number 575, 576, and that which is the situated in the northern side of the suit land, and it covers the Schedule C land. And in the suit lordship,
Schedule C line only says about doc number 844.
that is the wrong lordship. That is from that the whole problem has created lordship due to some wrong drafting of the learned counsel trial court lordship. The whole thing has created.
So you should ask for this amendment.
That is not been done lordship.
Then how can I help you?
Section 155, 152 lordship,
Who should exercise?
the executing court lordship. Because in
Executing court, can the executing court exercise 152?
Protiba Singh
Or
judgment-
sir, should the trial court do it?
Protiba Singh judgment lordship, Supreme Court held that a successful plaintiff should not be deprived of the fruit of the decree. In that case, Supreme Court demand back the matter to the executing court or trial court to invoke section 152 or section 40.
But how do I know it? Unless you file that petition.
That
You have not done that.
not-
Then what is wrong with this order?
Learned executing court held that lordship, kindly page 29 also. Page 29. It has been recorded in block letter also. Now the period of the judgment order decree passed in title suit number so and so reveals that the decree will be
It does
satisfied.
not provide that the land records of Schedule C land should be prepared and corrected separately in the name of Iman.
It has been passed
On
in
the
respect of
contrary,
Schedule land. Executing court held
We
that
simply
Schedule A
provided
land
for
should be corrected.
correction of the land records of so and so. Hence, it is abundantly clear that by correcting the land records of Iman, the decree can be executed properly.
in the case of the executing court.
But
has
Schedule C is a part of Schedule A.
Schedule a part of Schedule A. But
So Schedule A
executing
is made in your favor.
decree has been passed only in respect of Schedule C land. But the executing court goes beyond the decree and held that the decree has been passed in respect of for correction of Schedule A land lordship. But that is wrong lordship. But executing court cannot go
See,
beyond the decree.
Schedule B is a part of Schedule A land. Isn't it?
Yes, lordship, that is right.
Schedule C is a part of Schedule B land.
B land. But decree has been passed for correction of the record of rights in respect of Schedule C land. But executing court held that decree has been passed in respect of Schedule A land to correct the entire Schedule A land lordship. But in that case, executing court has gone beyond the decree lordship. And that is.
Hello, we set aside this order, then what happens? I'm not going to pass any order because you have not filed that application.
that is-
I'll only pass that order. To interfere with this, that it should have been decided as so and so, much so. I deem it fit that the decree is found to be fully celibate. See, Schedule A land, which includes Schedule land, is already recorded in the name of the decree holder. So if the Schedule A land has been recorded in your name, then why do you need the Schedule C? Because Schedule C is a part of Schedule A.
That is right lordship.
Schedule A is 2 bighas.
2 bighas.
Schedule B is 1 bigha. Schedule C is 2 kathas. So therefore, when the entire land is recorded in your name, why do you need the Schedule B, C land?
Land measuring 2 kathas 8 lessons has been wrongly recorded in first Kotian lordship. That is the problem. And while drafting the plain lordship, it has not been mentioned properly. Because only of this wrong committed by
No, no, I don't, one thing, Mr. Kolta, I don't understand. When Schedule A land is 2 bigas, Schedule B is a part of Schedule A land, Schedule C is a part of Schedule B land. Therefore, when Schedule A land is the 2 biga of land which includes Schedule B and C, then when Schedule A is in your name, why do you need B and C separately? Just for example, a dark number 1 contains 10 bigas of land, and in that dark number 1, there are some parts. Now, when that entire dark number is in your name, why do you need the others for correction?
Understand that, but the problem is that decree has been passed for correcting the Schedule C land. In the prayer, it has been mentioned that it should be recorded, it has been wrongly recorded as khas, and that should be recorded as Mary Bethel, that is dark number 844, which is a part of Schedule B land also.
But Schedule B land is a part of Schedule A land, and Schedule A land is in your name.
Now in the matter.
Then, why do you require Schedule C land?
So the land I have possessing lordship.
So we direct that the Schedule A land, your name be struck off. Only Schedule C should be there, if you are happy with this, because that should have been. So we strike out the name, direct them the name, the mutation in respect of Schedule A land be removed, the correction, and it should be only confined to Schedule C. You should be happy.
Land is properly executed, lordship, in the name of.
No, therefore we reduce it. Make that Schedule A land know it is the decree having been passed only in Schedule C land, comma. The question of any correction in the name of the plaintiff in respect to Schedule A land was not proper. What should have been done should have been only of the lesser area of the land, that is Schedule C.
In this case, lordship, there's another.
But there is no particular drag and Pattanava in Schedule C.
Only Schedule C. What they do is different. That is the area of 2 katha 8 lectures. So you see, Schedule A is 2 bigas 3 katha 12 lectures. So we remove the Schedule A, the entire land, make it only Schedule C, and say that the mutation or correction of records made in favor of the plaintiff or the decree holder of Schedule A land was incorrect. We make it only that it should be only for Schedule C land. So this remove the Schedule A.
Lordship,
Heard Mr. D. Kolita, the learned
sorry to
counsel,
interrupt,
appearing
Lordship.
on behalf of the
Lordship,
petitioner.
in this case, a decree has been
No.
already passed, lordship, and a matter of earlier RC has been filed by me, and the decree has been affirmed, lordship. So lordship may kindly given me to withdraw this petition, lordship. Withdraw this petition.
Better. Mr. D. Kolita, appearing on behalf of the petitioner, submits that he may be permitted to withdraw the petition. Taking into account the above, the instant petition stands closed on withdrawal. Full stop. It is seen that the LCR of the executing court was placed had been called for. The said LCR be returned forthwith by the registry to the learned executive. Mr. Francis appears for the response.
Item 9.
Yes, what are you challenging?
Lordship, in preferring title appeal, delay condemnation application of the respondents were allowed by the first appellate court against that. Lordship.
Huh?
Against that order, Lordship.
How much delay?
3 years, more than 3 years, Lordship.
What is the ground?
Ground, Lordship, they have not cited grounds. In fact, Lordship, their allegation is on the advocates, Lordship. Your Lordship, kindly see the petition. That is annexure 5, page 50. In this case, I have prayed for partition of 3 scheduled lands, and already, Lordship, execution petition has been, execution case already completed, Lordship. This is a case, Lordship.
When was the judgment and decree passed?
Lordship, that is judgment dated 29/6/2019.
That's the judgment date.
Yes.
And then?
Then they preferred their date of knowledge as per their petition 1/1/2020.
Ah.
Then they applied for the certified copy and all this, and thereafter they filed the appeal on 7/1/2023.
So it is not a delay of so many days, taking into account that during this period,
COVID was taken into consideration by the learned first appellate court.
and
My
then
case-
also,
My case, our suit was dismissed. Thereafter, I have filed one title appeal. First appellate court remanded the matter, Lordship, in presence of both the parties.
Hmm.
Thereafter, in the trial court, they remained absent during the entire proceeding, Lordship. Thereafter, suit was decreed. Lordship,
understood, but
kindly-
the judgment and decree was passed on 29/6/2019. There's no quarrel
That
with
is
that. So therefore,
As per their petition 1/1/2020, their date of
is
knowledge.
9/6/2019. 1/1/2020,
Yes,
their knowledge. So this is almost after 6 months,
yes, Lordship.
6 months.
They have to
Then
satisfy from-
15/3 to, then they obtain the certified copy on 8/1/2020. They should have filed this appeal before the learned court on, actually on,
Before COVID period.
before COVID period. Okay, but the delay is on account of the, what?
Lordship, even if we exclude the COVID period, they have to satisfy.
No,
from
what is the ground of the, yeah? delay?
allegation, Lordship, conduct of the advocate, page 50, Lordship, annexure 5.
No, where is the, how does the court take into account the mistake?
Lordship,
After they have got the certified copy, why the appeal was filed on 7/1/2023.
2023. They have they are pursuing the matter before bar council, but they have not preferred title appeal, Lordship. So I am objecting, Lordship. And in the meantime, we have execution already filed, decree, Lordship, already executed, Lordship. Possession of the properties were given out to all.
Where is the petition?
Petition page 50, Lordship. From para 4, your Lordship will find that on remand of the suit, as already stated, page 51. The petitioner's appellants engaged a senior advocate and 2 other juniors to appear and plead for appellant's dependents and maintain regular contact with the engaged advocates, but whenever the petitioner's appellants approached their engaged advocates, it was by them that they are taking proper care of the suit, and the petitioner's appellants need not worry about it at all. The suit was taken up for fresh decision with effect from 4/10/2018 continuously for next 8 consecutive dates, but the engaged advocates of the petitioner's appellants did not file the wakalatnama, nor did they appear in the court for and on behalf of the petitioner.
So amount was paid on 13,500 as fee to the appellant for filing the appeal. And that in spite of that, they did not file the appeal.
The advocate's fees.
Huh?
Fees for the advocate, Lord.
And other days, okay.
Where PA paid, Lordship paid a fee of rupees 13,500 only earlier.
For filing the appeal.
Lordship, that is after filing of the FIR and bar council. Their case is that on paragraph 7, they have stated that that the engaged advocates thereafter started persuading the petitioner's appellants to withdraw or compromise the said FIR case, giving an assurance that they would file an appeal before the appropriate court. But the petitioner's appellants asked their engaged advocate first to file the appeal and successfully set aside the judgment dated 29 June 2019. And then the petitioner's appellants would withdraw or compromise the FIR case, and in the process, long time elapsed, hopefully in waiting that the engaged advocates who were paid a fee of rupees 13,500 only earlier would
Filed an appeal, but they did not file, and instead of applying undue influence on the police, they stalled the progress of the police investigation, compelling the prisoner to file a complaint against them.
So they are blaming their engaged counsel, and moreover, Lordship, in paragraph 15, they have stated, page 54, that the impugned judgment decree has been passed with preconceived mind.
Now, that is a different thing. We are not concerned.
So they have filed FIR in the year 2020. They have filed complaint before Bar Council, but even then they did not file the appeal.
No, they gave the money to the advocate to file the appeal.
Lordship, it is
He
the
took the money and left the.
appellants who are required to file the, it is not by the advocate's Lordship. He has to sign the appeal, Lordship.
Fellow, we'll remember this as golden words from you from next time onwards.
Because,
Ah,
Lordship,
do,
it is
Amar,
their duty also,
let us
Lordship.
put it in golden words that it is the appellant who has to hand, the counsel has no responsibility out there. When the money has been paid to the appellant,
But there is no proof that they have prepared the appeal.
that is why they filed a complaint in 2022 against this person that you should have filed the appeal. Why you have not filed an appeal? They even went that the police is not taking into account and all these things. Anyway. Oh, okay.
And thereafter, Lordship, the first appellate court also did not discuss anything about sufficient cause, only on citing two decisions, Lordship. Their condemnation application was allowed.
You did not give me that judgment on that schedule.
Rajesh versus KK Modi, I have cited.
Rajesh Prasad Agarwal versus KK Modi is not on the schedule. Mr. Deka, what is that judgment on schedule? The schedule amendment of a schedule is different from amendment of the pleadings. There are two judgments, exactly on the point. There are two judgments. One is Rajesh, I know that, but it is not Rajesh Kumar Agarwal versus KK Modi is on a different thing. Amendment of pleadings is different from amendment of the schedule, of the description. The description is a different aspect of the matter. If there's something which is being left out, okay, this can be corrected. So therefore, what is done is you don't, there's no question of filing any written statement there against. There's nothing else because that is only put out there correctly. What is that judgment? There are two judgments. Yes, in 2008 and one is 2006. First is of the judgment of 2006 and the other is of 2008. Anyway, I've taken into account another judgment of Puran Ram. Puran Ram versus another one. That is Puran Ram is that is also 2008 judgment. Puran Ram. But why I remembered is because in Puran Ram, the trial court had in its discretion allowed the amendment. The High Court interfered and the Supreme Court says in 227, the court should not interfere when the discretion has been exercised properly. That is in Puran Ram. Puran Ram is 2008, 3 SCC, I suppose, isn't it? Yes. Because the case involved in Puran Ram is initially the suit was filed seeking specific performance of a decree, and in that case, the description of the land was not properly given. So he filed an application for amendment of the plaint, which was rejected on the ground that when he's asking for specific performance of the decree for an agreement, the the schedule of the land or the description of the land has to be same with the agreement. And this was upheld by the High Court. Thereafter, the petitioner went back again and filed another application, this time seeking amendment of the plain as well as the amendment under section 26 for correction of the agreement. And therefore, this amendment was allowed by the trial court. High Court dismissed the matter, went to Supreme Court. Supreme Court said nothing doing. This is a description of the land, nothing more than that. Prativa Singh is on another aspect. That is, Prativa Singh is on a different aspect. But this is a case of, so that is why. Why should they interfere? 227.
Already completed and lordship.
Chalo, then I'm yet to sign that judgment wherein you want that appeal to go back. So I take that also. Although I've allowed it in the court, I will take that in under advisement before putting my sign in my order that once an execution is completed, nothing is there. So one should not allow. We'll take it. Then don't make this submission.
They are continuously remain absent, lordship, during.
I'm not on that. I'm only on the question as to whether the delay should have been condoned or not. Now the court, having taken into consideration these facts, have condoned it. Should I exercise my 227? That's it. I'm on a very limited score.
Taken one judgment, lordship, which itself says delay may not be condoned, lordship.
Which one?
That money bundle. Page 79, one judgment was cited by the learned.
Yes, it appears there is some delay of around 300 days, 300 or 400 days. There is a delay, but the question is the explanation given. The explanation appears to be that after they came to know about this thing, then they asked some advocate to file an appeal. Appeal took the amount of rupees 13,500, but did not file an appeal, which led to filing of proceedings before so and so. And thereafter they engaged. But the petition is not so happily worded. It should have been better. But you never get good counsels nowadays.
There is a stay order also, lordship, while issuing notice.
At Miss So-and-so, the learned counsel appearing on behalf of the, Mr. So-and-so appears on behalf of the respondent. There is an application filed challenging the order dated 1/8/2024 passed in petition number 218/2023, whereby the delay of 3 years in filing the title appeal against the judgment and decree dated 29/6/2019 in title suit number
7 of 2019.
7 of 2009. Huh?
Third.
Title suit number
7.
7 of 2016. Was allowed. It is relevant to take note of the facts which were mentioned in the condonation application, which led to the impugned order, thereby condoning the delay. First, it has been stated in the application seeking condonation of delay that till 1/1/2020, the respondents herein had no knowledge about the judgment and decree dated 29/6/2019. As the learned counsel, their learned and as their engaged counsel did not inform about the said judgment and decree. Fusto. Thereupon, immediately applied for the certified copy of the judgment and order, judgment and decree dated 29/6/2019, which was received on 8/1/2020. It is further seen that thereupon the counsel the respondents herein had given an amount of rupees 13,500 to certain counsel for filing the appeal. And the said counsel did not file an appeal. Pusto. The non-filing of which, not filing, Pusto. Under the said aspect of the matter having come to light, comma, the respondents herein had filed various proceedings, have filed first information report, FIR against the councils, as well as also filed appropriate application before the Assam State Police Accountability Commission. Thereupon, it is seen that on 7/1/2023, the appeal was filed. This court had duly taken note of that the learned trial court, first appellate court, having taken into consideration these materials on record, had exercised its jurisdiction, exercised its discretion to condone the delay after arriving that the reasons assigned comes within the ambit of sufficient cause as mentioned in Section 5 of the Limitation Act 1963. It is relevant to take note of that, and it is very pertinent to observe, that this court is not sitting as an appellate court. The question arises before this court as to whether the discretion so exercised by the learned first appellate court in condoning the delay in filing the appeal against the judgment and decree dated 29/6/2019 was in accordance with law, was such which would require interference in exercise of the supervisory power. Taking into account that the learned trial court, first appellate court, had exercised its discretion, and the such discretion so exercised and the reasons so assigned in the said order does not appear to be such which shock the judicial conscience of this court. Accordingly, this court does not find any good ground for interfering with the impugned order dated 1/8/2024, whereby the delay of filing the appeal was condoned. Accordingly, this court doesn't find any merit in the instant proceedings, for which the instant proceedings stands dismissed. The interim order passed on 27/9/2024, whereby the further proceedings of title appeal number 1/2023 pending before the learned court of the civil judge senior division South Salman Vankasari was stayed, is hereby vacated, and the parties are being duly represented are directed to appear before the learned first appellate court on 21st of July 2025 for further proceedings of the appeal. Following the judgment of Justice Srivastava,
Here, the facts are like this, the properties involved in the partition suit are three, one at Guwahati, one at Shivasagar, and one at Morigaon. Now, properties at Guwahati and Shivasagar, were
that of the father, according to us, and mother had Morigaon. Now we have filed the suit for partition of all these three properties, my lord. So far as the will on the basis of which the defendants claim, my lord, that will was executed by the mother. So we are not just saying that the will is not duly executed, my lord. Our basic ground is mother could not have bequeathed so far as Guwahati and Shibuhagar are concerned. Because
What do you say about that judgment in Binapani court?
Binapani Kaur was concerning from 13 properties.
That is on the question of, but one thing very interesting in that judgment, 2006. One thing very interesting in that judgment is the suit was allowed to continue,
Subject to.
and if the suit is decreed, then the decree would be only provisional,
Subject to the.
subject to the outcome of the will.
Probate.
We can apply the same principle.
Problem in my way. What will be the degree, man? If the degree is passed, what will be the degree? Because the probate proceeding will affect the judgment of the suit. They have challenged all the.
What is the procedure, what is the stage of the suit?
The suit is, the WS has been filed by both the parties, and now they have applied for amendment of claim.
Understood, everything is
That is all.
understood,
So that is-
therefore it is
and
still
probate-
at the stage of pleading.
Yes, and probate is evidence of PW is going on, now the PW will cross-examine the PW.
So therefore, the question is, let the suit proceed, and if it is, the suit is decreed in favor of the plaintiff, the decree shall not become operational. It will be a provisional decree till the probate, the decision of the probate.
Madam, this is also very interesting question. Malo, if the decree is passed, suppose it is provisional decree, but decree is passed. Suppose the decree is passed that the mother's shares also they will get equally. Suppose the decree is passed, they will get equally. And regarding the other share which mother has inherited, what will be there? So,
No, therefore, what
so
happens?
the
of
degree will, again, the degree will have to be set aside on that account because
No.
because of probate.
It is not required to be set aside.
And
The
secondly, my lord,
decree would not be operational.
Hmm.
See that judgment. in,
I have seen it, but I have found the judgment, but I also, but how can that be done?
No, this was the case as to whether
Well,
an executor of a will,
mhm.
can he be made a legal representative? There the Supreme Court say in, I think just turn the last paragraph, last but one paragraph
Hmm.
of the judgment. Last- Next page, I think.
Hmm.
So the Supreme Court says that if a decree is passed, shall be remain as provisional till outcome of the probate proceedings, taking into account 213
Hmm.
of the Succession Act.
Hmm.
However,
Hmm.
if the suit is dismissed,
Hmm.
then it gets dismissed altogether.
Here in this suit, they have also challenged the will also. They have challenged the will also in the suit.
You cannot challenge the
They
will
have
in the
challenged the
suit
will also in the
Lord,
suit. That is the-
when the will has been already put to execution by probate.
My challenge to the will is this, my lord. My challenge to the will is mother could not have bequeathed those two properties. So it is the right of the testator to bequeath, which Kanwarjit Singh Dhillon says has to be decided in a civil suit and not a probate proceeding. So therefore my challenge is not just that she did not execute the will. My challenge is her testamentary capacity, which is again a question of title. Because if she is not the owner, she could not have made the will at all. So regardless of whether they prove due execution or not, if I succeed in the suit, my lord, that bequest is gone in any case. Because that is my main thrust. This is father's property. Why would the mother bequest, make a bequest?
Then how do I take care of Justice Srivastav's?
Because that judgment, my lord, doesn't, that judgment says that the only question in both these proceedings is whether the testator has executed the will or not. And that judgment, but in Kanwarjit Singh Dhillon's case, it was specifically held that the probate proceeding by then was already over. But nevertheless, the Supreme Court said that whether, regardless of whether there has been a proof of due execution or not, if the testamentary capacity was not there, it's a question of title which the civil court has to decide. So therefore, my lord, if my suit succeeds, my lord, whether they get the probate or not, ultimately, if my case stands, my lord, that probate will be of no value, and therefore, even in the state high court judgments, it has been held that so far as probate proceedings are concerned, there's no judgment in rem, but they are summary in nature, whereas civil suits are plenary. So civil suits can go also into the question whether the testator had the title to make a will at all.
Certain differences. My lord, actually, my lord, in Vinapani case, that was a different case. In Vinapani case, firstly, a title suit was pending. Title suit was pending. During pendency of the suit, the plaintiff had expired. And the plaintiff had made a will. So, during pendency of the suit, a probate petition has been filed. During pendency of the suit, a probate proceeding was filed. So, that in that case, question of title was already before the court. So whether the plaintiff had any right and title over the suit claim, that was already there in Vinapani case. That question was already there.
Where is the suit pending?
Morigaon.
And this one is?
It will come with them.
So why don't you then file a section 24 here? You transfer it there and ask the district judge to decide both together.
No, that was the course adopted in the other Supreme Court case, you know.
In Balbir.
Balbir, but Balbir has been doubted now.
Doubted is
No,
different.
it has been held to be very injury.
Where?
In Ravindranath Agarwal. Para 22 is discussion on Balbir.
respect now, the problem is the court says about 137. Can it be said to be a proper proposition when the Supreme Court's many judgments are saying the right of the of the executor, the legatee to seek the will is a noble duty, and as such he can file at any point of time. One. Secondly, Balbir Singh is of two judges. This is one judge,
That's the,
and one judge doubts the two judges.
cannot overrule, but it can definitely hold it to be per incuriam.
Didn't hold it as per inquiry.
It said 213 was not taken, and therefore, well, no, in fact, that other judgment which your lordship had, our High Court judgment, after that came Kumarjit Singh Dhillon. If I may just place reliance on that.
Yes.
9, 11, and 12. That question, whether the bequest is good or bad, or whether they have testamentary capacity, the testator, cannot be gone into by the probate court. So civil suit is the only remedy. Now, my lord, I have categorical pleadings.
In this case, the probate was obtained.
Probate was already obtained. Not, despite that, the court said that no.
Can.
You can.
Sir, you will be having two parallel proceedings.
Yes, yes.
Two parallel proceedings. Then
So in these two parallel proceedings, my lord, the
because
probate.
here the question in this Kanwaljit Singh Dhillon's question is that after having obtained the probate or letter of administration out there, can there be a suit challenging the probate, not a challenging the bequest so made?
Yeah.
The Supreme Court said that the will can, a testator's right, title to
Make the
give
bequest.
probate cannot be gone into in a probate
Probate
proceedings. And as such, by way of a suit, one can very well go in.
Now, so it's basically demarcated the contours that probate court will look into genuineness, execution, attestation. Civil court will look into also whether the bequest is good or bad, whether there was testamentary capacity, all of it. And in my plain manner, that is my specific case. That schedule 1 and 2 were the father's property, so mother could not have made a will.
What does Balbir Singh say?
Balbir, I think, was a very short judgment, my lord. It just says many issues may overlap. It just says many issues may overlap, so therefore there has to be a consolidation.
Because in the place, towns of Calcutta, Madras and Bombay, you don't need to take a probate.
You need to put, other than those, probate apparently is not even mandatory.
Now, here you have to take probate.
No, my lord. I think no. Not applicable outside the presidency.
Succession expense. This will require some year. We'll have it on some other date. Is there a stay to any proceeding?
It has been said, so we did not pray for an interim. Order was taken, order was taken.
It will be applicable, you see. Here you have to take the probate. Because of the fact, if you read 213 Roman 1, this section shall not apply in the case of wills made by Mohammedans or Indian Christians and shall only apply in the case of wills made by Hindus, Buddhist, Sikhs, or Jain, where such wills are the classes specified in A and B of section 57. A and B say to all wills and codices made by the Hindu, Buddhist, Sikh, Jain on or after September 1870 within the territories within which at the state date were subject to the Lieutenant Governor of Bengal or within the local limits of the ordinary civil jurisdiction of the High Court of Madras and Bombay. So we were under that.
Lieutenant General of Bengal.
Yes, was under Bengal,
But I recall it coming across a judgment.
1826. After that, it came under the British.
PT.
So it was came under this Lieutenant Governor of Bengal.
I'll check that history.
Huh?
That history I'm not very sure.
So therefore, once the British took over Assam, it falls within it. Therefore, they don't mention about the Calcutta High Court. You see?
Hello.
They only mention the High Court of
Madras.
Judicature of Madras and Bombay. Whereas here in two say, in case of wills made by any Parsi dying after the commencement of the Indian succession and which wills are made within the local limits of ordinary civil jurisdiction of the High Court of Calcutta, Madras and Bombay, and where such wills are made outside those limits insofar as they relate to immunes situated within these limits. Therefore, you require. Without a will, you cannot do anything. Why have you filed the probate?
I have not heard.
Whoever is it, still? So it seems Balbir Singh seems to be a safer way.
But the issues will not perhaps overlap because the probate court will not go into the question whether whether the mother had Joy Lakshmi Bora had title to bequeath. And Justice Srivasta's matter, here the probate was filed even subsequently, but nevertheless, for some reason, the court held that the suit will be stayed. But here we can distinguish it on facts because perhaps the only challenge in the suit was whether the will is genuine or not, which this court said that is predominantly within the domain of the probate courts.
I delivered one judgment on the question of whether the civil court can decide on the question of will can be, because there was a challenge being made that the suit was not maintainable in view of section 264.
Jurisdiction of this fact. But other issues of title going back, Amarjit Singh Dhillon.
My opinion, the best option is that one, Bina Panis.
Yes.
If we can mold the Bilapani and bring in, that let the suit proceed. What do you mean?
And the decree be subject to finding.
The decree is subject to be made provisional, pending the suit, pending the probate. And in prior to that, if the probate decree comes in, or whatever comes in, then in that case, the question will be, you may have to ask for, if the probate thing comes in, then what happens?
Then also, my lord, if I succeed on the first ground,
But how do you take care of it, that situation? Wouldn't it lead to a amendment
then
of the plaintiff?
challenging the probate. But then again, I'll be countered by 264 again, because powers of revocation are also with the district judge.
Now, revocation is, you cannot do so. But that is again not on the question of the title. Chalo, we'll hear again. The BD Deka, the learned counsel for the petitioner, and Mr. S. Sharma, the learned counsel appearing on behalf. Present proceedings have been initiated challenging the order dated 27/2024, passed in title suit number 13/2022, whereby the said suit was stayed pending disposal of the probate proceedings, which is pending before the court of the additional district judge number 2, Kamrup Metro. Full stop. Various issues have involved, various questions of law have been, appears to have risen on the basis of the submissions so made by the learned counsels appearing on behalf of the petitioners, parties. Full stop. This court shall further hear this matter again on 22nd of July 2025. This record. 29.
Keep it as part of.
Huh? No part of business. I think this order is enough to show it as part of it.
Obliged.
11.
Tiki kon bhorai. But Mr. Decker, think about filing an 24 if necessary, so that we can do it. Yes,
Yeah, with the-
challenging what?
Yeah, order date 1/3/2025. Next are A page 25 to 29. Okay.
What is this? What order I have passed?
For submission of original death certificate and
Huh?
submission of the death certificate and
You are challenging this, why?
the learned district court has rejected my prior lordship
For?
in the data of administration.
To appeal, there's an appeal filed under section
299.
299 of the Indian Succession Act 1925, challenging the judgment and order dated 1/3/2025 passed by the learned court of the district judge Lakhimpur, not Lakhimpur, in Miss Letter of Administration, case number 2/2019. The appeal is admitted, call for the record, steps be taken up by way of registered as well as.
12.
Please, your lordship.
Mr. Dutta.
Lordship, in this case, the the petitioner, he being a plaintiff, my lord, instituted 3 suits.
Huh?
My lord, the petitioner, as a
Instead of
plaintiff,
deciding the
instituted
state
3 suits.
application under order 21 read with section 47, it exercises under order 21. That given the subject matter of the suit is completely different from circumstances. Therefore, submitted the Okay, service is complete.
Service completed.
Now what has happened?
And thereafter, they have also filed one affidavit in opposition also.
Where is they? Who is appearing?
Some T. Gogoi,
Huh?
T. Gogoi, but I don't know whether he has filed the Wakalatnama or not, but there is a affidavit is there. It was filed on.
It is seen from the records that one Mr. Prosanto Gogoi had filed an affidavit in opposition in the instant proceedings on behalf of the respondent number 2, 3, and 4. However, his name does not appear in the cause list. First. Accordingly, list this matter again on is a stay?
No stay. Because my lord, my execution petition was stayed, my lord. Observing that the other two connected the title suit against this respondent number 2, 3, and 4.
Listed again on 16th of July 2024. Full stop. The registry shall show the name of Mr. P. Gogoi in the cause list.
13,
Lordship posed me a question as to why I am challenging this
Yes,
restitution.
custodial. Hey,
Restitution.
where is the restitution?
of
What do you?
Lordship, order 21 rule 32, your lordship. is the
Ah.
It says it can be executed by attachment of property. If I had the chance to obey the order and I deliberately disregard it.
Did
Yes, your lordship, order 21 rule 32.
you have properties?
Yes, your lordship, she is working lady.
Huh?
She is a working lady. She has immovables. And movable. Otherwise, lordship, a divorce case is pending, that was pointed out, and also a petition for domestic violence was filed. And the issue number 1 was decided that there was no good reason for her to stay away from the husband.
Is an appeal filed under section 219, the 28th of the Hindu Marriage Act 1955, challenging the judgment and decree dated 18/2/2025, passed in title suit M, number 1/2024 by the learned court of the district judge Sri Rang, thereby being a suit filed under section 9 of the Hindu Marriage Act 1955. Having taken note of the grounds of objection, the instant appeal is admitted, call for the record, steps be taken by way of register as well as
14,
and appears on behalf of the respondent on cause, on the petitioner appellant on cause, taking into account that this is the first time the appellant is not represented, this court for the ends of justice adjourns the matter to be listed again on 11th of August 2025.
15,
Mr. Bhagavati,
Lordship,
twice I have given you opportunity means your case is very bad.
Lordship, it is not exactly that bad.
Then why I have given you an opportunity twice?
Written evidence on affidavit, I have specifically mentioned that I exhibited exhibit 1, 2, and 3 in support of my right title interest. That document is not there, that it was during that document all those exhibit 1 and 3, 1, 2 and 3, it is not there.
Where?
And in the, at the time of delivering the judgment. And court, London trial court has said that as there is no document to so and so, therefore there is no document, as such suit was dismissed. Appellate court, we did not file petition under order 41 rule 27. We repeated the same thing because we exhibited two documents, but documents are not there. Now I have filed a affidavit to bring, even my documents are not there, even that the documents exhibited by the respondent clearly show that I have right to interest over the suit property.
Huh?
Clearly shows that I have right to the interest of the suit property. That is, therefore, I have not, my documents are not there, but exhibited document by the respondents, respondent A and B, exhibit one, A and B, clearly shows my right to the interest in respect of the suit property. 3/17 lesser. That record, that has not yet come on record. Lordship, we filed it on 13. Let the affidavit be put on record so that
You
will
also
be-
bring your evidence on affidavit and
Lordship.
cross-examination.
Lordship, that in the cross-examination, there was no such question was asked. And that I will bring that
So
also.
was there any cross-examination and asked on those documents? No.
No,
Obviously, that means the document was not there. And without the marking done on, in terms with order 13 rule 4, how can this document be said to be there?
that is why by as a last resort, I have said that if my documents are not there in the record, documents exhibited by the respondent, so also shows by right to the interest over the suit property.
What is the document given by them?
It is because same document, it is the exhibit B, is the same document which I exhibited as exhibit 1. Exhibit B is the document exhibited by them as exhibit B.
Okay,
Jamamundi copy.
let us see that.
I have that affidavit is yet to come on record, Lordship.
My lord, kindly produce the page number 7.
Exhibit B is the certified copy of the Jamabundi.
Lordship,
Exhibit C is the sale deed.
sale deed.
Sale deed by whom?
Sale deed by respondent number 3 in favor of the respondent number 1 and 2. So that-
So that is
that
nothing
is
to do.
not that, or his right is not there, that the
Then-
sale deed will not,
Certified copy of the order dated so and so.
Lordship.
Then, so you are claiming your title on the basis of Jamamundi.
Jamamundi.
Huh?
Jamamundi,
So your name is there.
yes, my lord. In
So Jamamundi mutation of mutation,
mutation.
revenue
Jamamundi,
records.
revenue records.
So revenue records, I should declare title.
Even their title is also based on the revenue records only.
Huh?
Their title is also based on the revenue records.
But they have a sale deed.
Sale it subsequently on the respondent number 3 has the, he claims that he is the owner. He sold it to respondent number 1 and 2. So their sale it only when the title of
He's the defendant. He has no business. The weaknesses of a defendant's case has no relevance in a suit for declaration.
Before that only let that revenue record also come.
So your case is therefore weak.
I don't say that very weak, but I have
My
a
lord,
definite case.
kindly produce the page number 7, or paragraph number 4 of the memo of appeal. The appellant himself stated that, your honor, my lord,
Number.
paragraph, page number 7, paragraph 14. For the exhibit B, that is the Jamabundi, it is clear that on 29/6/1999, the name of the plaintiff number 1 was recorded in respect of land measuring 3/7 in the suit that, and hide order dated 29/8/1999, the name of the plaintiff number 1 was recorded in respect of the 3/7 of land of that number of said that number. That the suit of the plaintiff was instituted on 24/2/2010, but during the pendency of the suit, so the name of the plaintiff number 1 was struck off from one entry in respect of the part of the suit land measuring 3/17 dash of hide order dated 31/3/2010. Your Honor, the exhibit Annex A submitted along with the additional affidavit, it clearly shows that the order which was granted mutation on 26/9/99 was set aside by the SDO Rangya by his order dated 31/3/2010.
And when was the suit filed?
Before that,
Suit was filed 24/2/2010.
So you sought for an amendment of the plaint, I
Yeah.
suppose.
Not lordship, actually that notice was serving without serving notice upon.
What do you mean?
No, even.
If you, how, Mr. Bhagavati, the question is very simple. It can only arise, a substantial question of law can only arise if there is in any manner something foundation laid down in the pleadings.
Lordship, I had,
How
I-
much time do you require any further for having a satisfaction that your matter is there?
Lordship, because why? Because 3/17 Lassa, it was not my alone land. There was another 3/17 Lassa. Even then I had the right, even if my name was,
You could not have proved your judgment, your title on the basis of the.
because in that case, the defendant's document clearly shows that I had the right.
That's Jomabandi.
Nobody.
So you cannot prove. Let us transpose this exhibit B to
That is- that is-
yeah,
that is
but
my- that is
then
my submission.
then
That is
also
my
you don't.
submission.
Then also you don't have a case.
I have a case. Because no, in that case, even if that my name was struck off from that 3/17 Lassa, I have an additional 3/17 Lassa. So I had the right. I have the defendants number.
Again on the basis of the Jomabandi.
No, Zivamundi, but
Then-
even Zivamundi, it was, no, Lordship, it is, there it was said that Khada, Horida Hutre. Because that, there was.
So if it is a corrida hotre, then obviously you will have a sale deed.
Sale deed, it was very old sale deed, I do not know why they did not produce it, because that was, it shows that, the entry shows that Horida Hall. The Horida means it has, there was a document and we stated.
So if there is no document out there, you have produced, so you fail.
Lordship, that is why my submission, because that my document.
Your submission is very, it's a very pathetic submission out here. Mr. Bhagavati, okay, we fix it, giving you another chance.
My lord, kindly-
And when it becomes the third date, then it is immediately to be dismissed.
My lord, kindly page number 23, that is the written statement filed by the defendant in trial court. In paragraph number 9, it is clearly stated that on 29/8/2008, the legal heirs of the late or.
Are you on caveat, Mr. Counsel? Are you on caveat? Take your seat. Mr. B.K. Bhagavati, the learned counsel, appearing on behalf of the appellant, submits that he has filed an additional affidavit. Full stop. List this matter. However, the said additional affidavit is not on record. When do you want it? After vacation or before?
After vacation.
After vacation. So the bench hopefully changes. 16th of July 2025.
Could be.
Supplementary item 43.
Lordship, for direction of this honorable court, we have submitted the court fee, Lordship. But it is from the office of the revealed that court fee has not been submitted. So far,
Okay, Mr. R.K. Bhuyan, the learned counsel submits that the court fee has been duly submitted. Full stop. However, from the office note, it reveals that the court fee have not been submitted. So taking into account the above, the registry shall appropriately make necessary, shall look into the aspect and then place the matter again before the court on 23rd.
are we allowed to change the cost title, Lordship? Cost title is to be changed.
What happened?
Lordship, regarding payment of court fee,
They will put it. No?
Lordship.
Stay matters item 33.
That लिखी हुई है, the registry shall taking into account, the registry after inquiry, if it finds that there is an additional court fee paid, the same be reflected in the memo of appeal. What is this? Stay matter, what is the stay? What have you asked for stay?
This CRP, we have
I
filed
do not
against,
find any cause to allow the petition for withdrawal with liberty to fresh.
Lordship. We have filed this CRP against order dated 30/11/2021. The impugned order is at page 31, Lordship, whereby my application under order 23, rule 1, sub-rule 3 is rejected.
Oh, this petition. Rightly dismissed, na?
Yes.
Lordship, Lordship, I want to rely on one judgment which
No,
says
you
that-
don't rely on, because what is your petition? Have you
Lordship,
seen the petition?
Lordship, I have seen,
No,
I
can't
have
help
seen.
it.
But there are many formal defects in the.
I can't help it.
plain-
How do I do it? Taking into account that what you have mentioned in your petition is 2 paragraphs.
Lordship,
Kindly see.
I can't change that, Lordship.
Kindly see, you can't help
Yes,
it. Mean, I can also help with the plaintiff at the time of filing the instance suit caused some lapses in the plaint, including material defects which cannot be cured by way of amendment of the plaint, and as such, the plaintiff has no option but to withdraw the suit. That's why he withdraws to it.
Lordship, may I place the.
Yes,
factual
please.
Lordship, this suit was directed against the defendants because their names appear in the revenue records. To strike out their names and the plaintiff's name may be included because we have inherited the landed property from the Giri Kumari estate. But what happened, Lordship, actually, the counsel was very novice. He was just having 1 year experience in the bar. And the plaint had many formal defects, Lordship. The schedule is not proper. The parties are, Lordship.
How do I help you?
I may be allowed to file a fresh application under Order 23, Lordship, then. Because he actually, this was the
Ms.
counsel.
So-and-so, the learned counsel appearing on behalf of the petitioner submits that there are various formal defects as would appear from a perusal of the plaint, inasmuch as the reliefs which have been sought for, comma, semicolon, the schedule so mentioned in the plaint, as well as the parties who have been impleaded.
There are some dead persons, brother. They filed a suit against some dead person.
Parties so impleaded, which included various dead persons. Be that as it may, it is relevant to take note of that the present proceedings is taken up at the stage of taken up under Article 227 of the Constitution. And under such circumstances, comma, this court can only look into what order has been passed by the learned trial court, and in respect to what petition, what application the plaintiff had filed seeking withdrawal of the plaint. The application so filed is bereft of any particulars as to where the formal defects or other causes for which the plaintiff should be permitted to withdraw the suit with liberty to refile. The learned counsel appearing on behalf of the petitioner therefore submitted that as it was the fault on the part of the counsel who was representing the petitioners for which a proper application could not be filed, liberty be given to the petitioner to file appropriate application before the learned trial court, seeking withdrawal of the suit by giving proper detailed material, by providing proper material particulars. She further submitted that in the eventuality of such application being filed, comma, the learned trial court be directed to consider the same without being influenced by the impugned order dated 30/11/2021. So, taking into account the submission, as well as upon perusal of the claim and the application so filed, it appears that the manner in which the suit had been, the plaint was instituted, and the application which was filed, comma, do not contain material particulars for which the learned trial court could have exercised the power under Order 23, Rule 1(3). of the court. Considering the above, this court permits the instant petitioner to withdraw the instant petition. This court finds no ground to interfere with the order dated 30/11/2021, passed in title suit number 215/2018 by the Learned Court of the Civil Municip number 1, Karimganj, whereby the petition number 432/43 was rejected. Be that as it may, this court observes and directs that the decision so rendered dated 30/11/2021 shall not preclude the petitioners to file a fresh application for withdrawal of the suit with liberty to file afresh by providing due reasons. It is observed that in such an eventuality, in such circumstances, if such application is filed, the learned trial court shall decide the said application on its own merits without being influenced by the order dated 30/11/2021. This court it is seen that by an order dated 12/8/2022, the further proceedings of title suit number 215/2018 was stayed. The said stay order stands vacated and the parties who are duly represented are directed to appear before the learned trial court on 14/7/2025 for further proceedings of the suit.
34.
Transfer petition, praying for transfer of a case from family court Dhubri to the court of district judge Kokrajhar. Service was refused and was deemed to be complete as per order dated 2/12/24.
What is your ground?
Worship, inconvenience, and also there are other cases pending at Kokrajhar, Your Lordship, but the husband is appearing. The maintenance.
Why there are two wives?
Only one. wife.
Then why
The
are two
mother is,
petitions?
the mother is also made a party by the husband.
In what matter?
In restitution.
Restitution.
Mother is
Okay. You file written statement.
no lordship.
This post written statement filed on 18th. Which court you want?
Kokrajhar district court.
Huh?
District judge Kokrajhar.
35.
None appears on behalf of the petitioner on call. It is seen that on an earlier occasion also none has appeared on behalf of the petitioner on call. It appears therefore that the petitioner is not interested in the instant proceedings for which the instant proceeding stands dismissed for non-prosecution. The interim order passed on 28/6/2023, whereby the further proceedings of title suit matrimonial number 113/2022 pending before the court of the learned district judge Tinsukia was stayed is hereby vacated. The court of the learned district judge Tinsukia shall proceed with the disposal of title suit matrimonial number 113/2022 in accordance with law. The registry shall duly intimate about this order before the learned trial court.
36.
Wait, please, Lord. In this matter, I am newly engaged counsel because earlier counsel has handed over
all the file to the petitioner. The petitioner in bed, he was suffering from very serious ailments. Therefore, he could not submit the documents to me, my lord. Therefore, I could not file the Bakaratnama. Recently, I have filed Bakaratnama, my lord. And the lordship, therefore, for admission, my lord, this matter come out after 1 week, my lord. In the meantime, your lordship has already on 5/5/2000.
Yes,
Your lordship has already vacated the stay order.
yes.
So, my lord, for the hearing of the entire matter, my lord, let this matter come out after 1 week, my lord.
Huh?
Next week, my lord.
What should I do?
Because I have received, my lord, this entire file recently.
What is the case about?
And there's one petition was filed under order 6/17 for amendment of the claim. That was rejected by the Learned Trial Court.
Why?
Because it was delayed. It was delayed because one plaintiff was already
What is wrong with the
cross-examined.
trial court writing such a long order?
Yes, my lord.
Yes means what?
No, my lord. I am not the counsel in the trial court also. Only in this case, I have been engaged newly, my lord. So I need to.
The finding of the learned trial court is that by amendment, they want to change the entire nature and character of the suit. This is not the, let's say, earlier the claim was amended.
Where is the amendment application, Mr. Kaya?
Not see.
Huh?
Page, my lord, 1201.
95 is application,
No, no, no.
95,
Amendment application.
95.
Page 95.
What is the stage?
But see, for one witness was examined and cross-examined.
Where is the claim?
Page 27.
There's a new plaint. Have I vacated it?
Yes, Lord.
Yes,
Five,
yes,
five.
Now, when do you want a date for dismissal?
Next week.
When?
And
Give
the
a good
only
date.
fact is that
We
you-
don't have 13 left. When?
Your lordship may fix any date, my lord.
I'll
Because
make it.
only fact
We'll
is
have the double of it, 26.
applied. Due diligence not shown, this is the fact of the liar.
Absolutely. Not only due diligence, we have sought for the entire plaint. What is
37.
left?
So the petitioner has changed and as many as 5 advocates in the trial.
Huh?
Till date, they have changed 5 advocates. In trial.
And not only that, he has changed means
Yes,
to
entire
change the nature and character of everything.
Yes, everything.
One thing good, I will write up only.
Item 37.
Yes, who is appearing? Chalo. None appears on behalf of. None appears on behalf of the petitioner. On call. It is further seen that in spite of direction to take steps by way of Dusty, no such steps have been taken. Considering the above, as the service, considering the above, this court is not inclined to extend the interim order passed on 19/2/2024. Accordingly, this court therefore directs the Principal Judge Family Court number 3, Kamrup Metro at Guwahati to proceed with the disposal of FC Civil Case number 466/23 and Ms. Z case number 32/2023 in accordance with law. The registry shall duly intimate both the parties, to intimate the learned court about the instant order.
Okay.
Yes,
Madam.
service,
Transfer for a restitution of conjugal life test from.
which court to which court?
Lasipara to Kamrup Metro, Family Court.
Yes,
Lord, since cause of action arose in the Mulot Glasipara, and she is temporarily stay here. Her permanent resident in the district of Borpata. So how Mulot she will arrange, and of course the respondent number 2 has no problem.
who is respondent number 2? We have only one respondent.
Yes, sorry, yes, only one respondent, Mulot Moibul Islam, the husband.
We have no problem.
He has no problem.
Transfer. File your written statement.
No, madam.
File your written statement on 14th of August 2025. Transferred.
In which court, Mulot?
Eh?
In which court?
Wherever he is asking, where?
Yes, madam. Family Court, Kamrup Metro.
Nah, then but it may be number 3 because another suit is pending there.
Oh. Either pending asset that, so transferred.
39.
Obliged.
Ah,
We have called the justice service. The office note says, 13-6, in respect of that registered post, the address cannot be located. Address we have served the trustee.
you have effective service by Dusty?
Yes, ma'am. We have filed the affidavit.
This court duly takes note of that pursuant to the order passed by this court on 28/5/2025, service upon the respondent. So respondent have been duly completed, duly effected. He did not accept.
No, madam. He accepted, he signed, put his signature on the back side of the note.
Have duly accepted the same. on 6/6/2025 by putting his signature. Accordingly, the service upon the respondent is deemed to be complete. Full stop. It is further taken note of that the respondent, however, has not appeared. Full stop. Accordingly, for the ends of justice, the matter stands adjourned to be taken up again on 28/7/2025. The interim order passed earlier on 28/5/2025 shall continue. till
40,
It also, we have effected the justice service under respondent lordship. We have filed an affidavit. Page 40 of the affidavit annexure 8 shows that it has been duly received.
Oh, this one,
That,
affected.
yes.
It is seen that pursuant to the order passed by this court on 2/6/2025, comma, service upon the respondent number
1 and 2.
1 and 2, who has received for 2?
Who has, Bolin Fukon, it is the respondent number 2. Both are brothers.
The respondent number 2 had accepted the service on behalf of the respondent number 1 and himself, as would appear from the return of the dusty service. So taking into account the above, the service upon the respondent, there are two respondents,
There are 2 respondents.
are duly complete. Full stop. However, none has appeared on behalf of the respondents. Full stop. For the end of justice, the matter stands adjourned to be listed on 23rd of July 2025. Interim order passed earlier shall continue till the next date. It is observed that if the respondents do not appear on the next day, this court shall proceed to dispose of the instant proceeding in their absence. এই আগৰ কেছটোতো এইটো order দিবি। Last line.
for orders item 16,
For office note dated 11/6/2025.
Service complete. Service being complete, list the and the NCR having been received, list the matter for hearing in the usual course, liberty given to both the parties to file appropriate application for early hearing. But service not done.
Lordship, they have an office here in Guwahati, but it does not exist here anymore.
Huh?
The respondent, they had an office here in Guwahati, but it is not there anymore. And their head office is in Delhi. So Lordship may give us an opportunity for paper publication.
File an application. Learned counsel submits that the service could not be meted out upon the respondent by way of the state. Taking into account that there is no office presently of the respondent at Guwahati, he submitted that he may be permitted to take steps by way of by paper publication. Considering the above, the permission to file, to take steps by way of in the substituted manner would require filing of appropriate application. It is observed that if such application is filed, appropriate orders will be passed. Service complete.
Service company, both the parties are here. Lordship.
Okay, service being complete and the LCR having been received, list the matter for hearing in the usual course, liberty given to both the parties to file appropriate application for early hearing.
18 matters, my lord. Date may be fixed, my lord.
What?
2018's matter, my lord. As you lordship, my lord.
Earlier 2017, I passed an order similar. This would show that I am very unjust to any.
But in the month of July, my lord. In the month of July, my
Service being complete and the LCR having been received, comma. Is the matter received, comma, Mr. So-and-so appearing on behalf of the
Not in July.
claimant submits that a date may be fixed as already 7 years have passed by. Pusta. List the matter again, matter on 12th of August 2025.
Oblige,
For
my
hearing.
Oblige.
19,
Service not complete among respond number 2 and 3. Service being not complete against the respond number 2 and 3, the petition appellant is directed to take fresh steps upon the said respondents by way of registered as well as usual within 7 days from today.
Oblige.
20 and 21,
Same order.
22, item 22.
What is there?
In this case, actually, we have to see whether he has to deposit the statutory amount because he has filed cross objection in my appeal.
Which one item?
Item 2021. Item 20 and 21.
2021.
Yes, sir.
Here the service upon respond number 2 and 3 is not complete. That was what the people, Mr. A.R. Agarwal appeared. ভুলকে appear করছেন। আমি কি list কোন করছো? ওই গন্ডগোল করা নাই তো? সব করবো না আর।
আমরা তো 2021
Why is A.R. Agarwal appearing?
in 19 months.
19.
19 to কি আছে? 19 to কি open আছে? Into steps by way of the speed not taken, not received. And 21. Yes, 20 and 21, the question is, without statutory deposit, can you file a cross objection?
I have discussed with some of my colleagues also. That it requires some clarity because so far I have not filed any, even I have some others. They did not deposit statutory depositors. They did not made before filing cross. For filing cross objection, no statutory deposit. Some clarity is required, your lordship. Clarify the situation to be good for everyone.
That occurred me, Lord. Going through the one case I have filed by Honorable Supreme Court and the ratio decidency of this case, if applied in Motor Vehicle Act, in that case, the cross objection is not even maintainable.
Huh?
Is not even maintainable, cross objection.
By the insurance.
But not only insurance, because the ratio decidency. Because in this case, the right to file appeal is a substantive right, and that has to be specifically provided.
No, if we go by the Banarasi Das judgment, which is subsequent in point of time, yes, if he wants to not challenge on anything on the quantum, if he doesn't want to challenge the quantum, what he is challenging is certain observations so made, which may, otherwise the issues have been decided in his favor, but certain observations which have an impact on him, then obviously he can raise a cross objection. That is Banarasi Das. Have a look at that. This is on order 41 rule 22.
Banarasi Das Rampal.
Huh?
Banarsi Das Rampal, there is another one also. Swaminathan versus there is also another.
The Banarsi Das, I think, is on the point. on that
Banarsi Das Rampal versus.
Categorically say when it is required. Means you need not, otherwise also you need not file it. But the moment you want to touch, just for example, I'm just in a motor vehicle act. If a person concerned, a motor vehicle, the insurance company passes, there's a decree so passed, whereby the insurance company being agreed has approached the court. The other guy does not have a cross objection. And the monthly income which is being held, just for example, has been taken as 10,000 and the insurance company has assailed them. But on the other hand, the other side wants 15,000, but he has not assailed it. He cannot raise it. Okay. But on the other hand, certain things like on conventional aspects, these are to be given to him in terms with 141. Then in that regard, without having a cross objection also he can get it. But otherwise, if he wants an enhancement, it has to be, then it is required. And if he's challenging on certain things, therefore order 41/22 comes in that aspect. That you have to challenge to that aspect. That is more like a cross appeal. Not a cross objection, it's like a cross appeal. And therefore the limitation, he would, because normally he need not file it. He has filed it to protect the award. Otherwise he would not have filed. So you see Banarsi Das. Yes. But the issue is how much you have to pay, whether there should be a statutory deposit or not.
The problem is the issues are very small, 7,000 and 30,000.
We'll see. Take it. We'll have it some other day. Okay. List this matter again on 16th of July 2025. Okay. Yes, Mr. Samari, your matter.
There is a case, my lord, the Chavua Town Committee wants to create a new construction over the old building, my lord, market.
What?
And, my lord, the Chavua Town Committee,
What are you challenging here?
my lord, I am challenging page 63, my lord. My lord, the execution order has been passed against me when I am also the decree holder, part of the settlement. Now, lordship, kindly see the contention of the learned court below in page 64, paragraph 2.
Art learned evidence, judgment they took from the report as well as when details of the judgment they took do not apply.
This statement that as per compromise.
Thus, the appeals of judgment pleadings is for the purpose.
Now, lordship, just take a turn, page 33, paragraph 2, part of the compromise settlement. Page 33, paragraph 2, deed of compromise. That the first parties have agreed to give allotment of shop in the new RCC building to be constructed by Chavua Town Committee under 10% PFN for any state to the members of the second party after construction of a new shop premises, new market complex and
After
second
construction of new shop premises,
madam.
that is new market
complex and second party members shall be entitled to get a shop premises on the ground floor as per the record of the Chavua Town Committee. That means the discussion is about the town committee that after new construction, because there are 29 numbers are litigant there, all have been allotted. 22 already now carrying out their position, etc. Only 5 are creating problem that they are not in satisfactory to the level which they are sought for that area of that shop. Some they are creating dispute on 2.1 is site and number 2 location. They want suppose left allotted to the right. Suppose they want that who is sitting on left, that has to be evicted. Now let's just take time for a moment. My page 35. It is the part of schedule. Page 35. 27 nodes of soft premises in new RCC constructed building on the Chabot Town Committee site situated at Chabot Town Committee. Therefore, based on my lord, that all allotment has been granted, there is no dispute to that effect. Now, lordship, on a particular date, my lord, the learned court will even pass an order for Nazir, my lord, to visit the inspection. Now, once that inspection was done, my lord, to the ground, it is found that the all allotment are in the name of, my lord, the persons who are putting rivers. But because, my lord, that newly constructed, suppose there is a square, my lord. Now, there is a bigger area, it has been divided. One part is given to one side, another part is given to me, suppose. Now, he wants to say that no entire area to be given to him, that there is one kind of dispute is creating. That is the part of the Lazi report. Now, lordship, kindly see that order, what order is suffering from infirmity, my lord. No schedule, no party's name, nothing. And even, my lord, in terms of the section 21, rule 24, process has to be issued. No process has been issued.
Who are you?
I am the person's, my lord, part of that compromise decree holder to whom that swap has already been allotted. Because I am adjacent to the persons, therefore, suppose that which was also allotted to them, they want to evict me. Now, it is a matter of settlement that because there is a diagram out of which.
Who is appearing for Sabua?
Sabua, my lord, we have just made a party, that notice will go, my lord.
Sabua is the main person who is to do
Absolutely,
it.
my lord. Now, second lordship, kindly see, lordship, that in case of, my lord, executing a decree, order 21, rule 24, process must be issued, my lord, indicating the property details, the person's concerns, and, my lord, date fixed for suppose execution, etc. Now, in a state where a police has been given the full authority to, my lord, evict us, my lord. Lordship, assume to the 106 numbers of shops are there, my lord. Can you see what law and order situation will be, my lord, happen there? Page 65, my lord. See that what kind of harsh order has been passed. Only relying on the Nazis report, my lord. And lordship, the whole contention is wrong.
Who
It's
is
saying
Sabua? You are appearing for whom?
For the, my lord, the private respondents, my lord, I filed the.
226?
226, my lord.
Huh? 226?
6, yes.
You are appearing?
Yes.
And how about Sabua?
Above, my lord, notice will go, my lord.
They are the main person.
Absolutely. But lordship, can you see that what aspect is there? My lord, Chabua is there. But question is that, but suppose I am also a decree holder equally. I am not a stranger. If suppose they want to execute against me, even, my lord, I have to give a notice, my lord. No notice was even served to me that this is the
Please
position.
consider that. Issue notice making it returnable on 25/6/2025. Mr. A.K. Gupta appears on behalf of the respondent number 226. As regards the respondent number 1, the petitioner is directed to effect service by way of the stay routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the order dated 27/5/2025 passed by the learned court of the Civil Judge Senior Division, Dibrugarh, entitled Execution Case Number 02/2017, wherein there is a direction being issued to the civil Nazir to execute the decree passed by the court, and if required to evict the soft premises and to hand over the same to the decree holder. It has been further directed that the decree holder, decree holder shall also render all necessary assistance to the officer in charge of Sabua police station to be implemented in full force. Mr. As summary, the learned counsel appearing on behalf of the petitioner submitted that without a proper adjudication, this order is been passed, which would affect the rights of the petitioners who are in occupation of the sub premises. So taking into account that the matter would be looked into, is required to be looked into, is to be taking into account that this court is of the opinion that the matter requires some consideration. Accordingly, till the next date, the further proceedings of title execution case number 02/2017 shall remain pending before the Court of the Civil Judge Senior Division Dibrugarh shall remain stayed.
Only humble request, Lordship, if it's possible to upload that order, my lord.
Ah?
If we upload the order, my lord, at least we serve the copy,
Upload the order when
today if possible.
the matter is there.
Yes, tomorrow is the date
Order
of,
was passed on 27/5 and you have woken up today.
no, my lord.
You want this order?
Anyway,
Habeas stands research.
May I breathe?
You want any dates or any extension of the any interim orders, he will give it to you.
There's an objection to an extension of an interim order.
Let it be till before vacation.
Till.
Before vacation, any
Lordship,
date
the
may be.
matter The lower court is fixed on 20th of June.
20. Okay,
Yes.
leave the matter on 18th.
Yes, Your Lordship.
18 interim order
Yes.
shall pass.
Yes, I'll-
Vijay Bhai.
no, item 46, can it be on Wednesday?
2021 also. In the month of August, July also, I'll be under an operation.
No, it's okay, you take a date.
Okay. Problem.